The Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thank you. Good morning and welcome to the Appeals Court session in courtroom 4 for April 8th, 2024. Your panel today is me. I'm Greg Massing. To my right is Justice Shin. To my left is Justice D'Angelo. And we have 6 cases today, 3 criminal, 3 civil. And I understand like the first 5 are here, so quick ground rules. We have 15 minutes per side. There's no rebuttal, so get out. So try and anticipate what the other side is going to say if you're the appellant. We are familiar with the cases. In fact, all the case materials are on these here tablet devices. So if you catch us looking at our tablets, it's not because we're distracted, but we're actually looking at case materials. And as I said, we're familiar with the case. You can just jump right into it. You're free to use your entire 15 minutes, but there's no penalty for finishing early. So with that, I will call the first case this morning, which is Commonwealth versus Hillen Orana, 23P497. Morning.
Morning, Your Honors. My name is Edward Gaffney, and I represent the defendant, Hillen Orana. Mr. Orellana is appealing today his conviction of the lesser-included offense of indecent assault and battery on a child after originally being charged with rape of a child. My claim today is that the trial judge erred in giving the lesser-included offense instruction to the jury, basically giving them the option of convicting on the lesser-included offense, which they took.
Can I just to clarify, you're arguing that the instruction was incorrect. You're not arguing insufficiency of the evidence.
Correct, Your Honor. Well, it turns into a sufficiency adjacent argument once the jury comes to the conclusion that there was no penetration. At that point, then it is as if it were a sufficiency argument because the case never should have gone to the jury on the lesser included offense,
right.
Which
and again, there was a required finding of not guilty at the time of the evidence was closed wouldn't have worked because there was evidence of penetration.
Absolutely, Your Honor. That was straightforward, and actually fairly. I think that the fact that this case had no, the Commonwealth's case rested entirely on the credibility of J.C. It was her testimony only. There was no physical or forensic evidence corroborating the allegations. She basically said, I was in an apartment with 3 other people. The defendant pulled me by my wrist into a room, closed the door, pushed me down on a bed, pulled off my pants, pulled off his pants, got on top of me and vaginally raped me. That was...
I can stop you right there. Isn't the law clear that a jury can believe just a portion of an alleged victim's testimony but not the whole thing?
Absolutely, Your Honor. And
so just based on what you just said, and I'm sorry to interrupt you, but I want to follow up on what you just said. Mm-hmm. Everything that the victim testified to except for penetration. Exactly. Why isn't that indecent assault and battery?
Well, if the general principle that Your Honor just articulated, that is that the jury is allowed to believe everything or nothing or a part of what a witness, in this case a victim, states, then there would be no error. There would be no error in this case, and there would be no error in any case, any rape case, where a victim, where a jury was given a lesser included offense. The issue here is, it's not just that general principle, because when you're dealing with a lesser included offense challenge, there's something more than that principle at play. What's at play is that the jury has to, when we're coming down to a conviction on a lesser included offense, the jury has to have a reasonable basis, a rational basis on which to acquit on the greater charge and convict on the lesser included charge. And that's what happened in the Ortiz case. In the Ortiz case, the defendant in that case was accused of oral rape and anal rape. And he said he was not guilty of the oral rape because he said it was consensual. He said he was not guilty of the anal rape because it didn't happen. And this court vacated the conviction of the lesser included offense with respect to the anal rape because basically it was an all or nothing situation. There was no evidence on which the jury could come to a reasonable determination that there was a sexual assault, but there was not penetration. And my argument here is that's exactly where we are in this case. Basically, there's nothing here. She repeatedly said, he put his penis inside my vagina. And there is no basis on which the jury could come to the conclusion there was a sexual assault, but there wasn't penetration.
Wasn't there also testimony where she said she was still a virgin?
Yes, there was one.
Why, again, and I know the JC is a young girl, but why isn't that enough for the jury to say, based on that, I don't think there was any penetration because she said, I'm still a virgin, and she passed out during the episode?
Well, the passing out, I mean, you know, she said, her testimony was that he put his penis inside my vagina and then I passed out. Now, there were multiple prior inconsistent statements with respect to virginity and not virginity, none of which formed a reasonable basis on which the jury could come to a conclusion that there was a sexual assault and not penetration, because those statements were put into evidence only. They were limited, and the jury got this instruction. Those statements were limited to JC's credibility only. They were not introduced for the truth of what was said in the statements. So the jury couldn't rest a reasonable basis. The jury couldn't find a reasonable basis for determining, well, there was this attack, but he did not ever penetrate her, because those statements weren't put in for their fact purposes.
So this instruction wasn't objected to, right?
Correct, Your Honor.
Okay, so how does that factor into our analysis?
Well, I'll take the question in two stages. The first one is the obvious one. Without an objection, the standard of review is substantial risk of a miscarriage of justice. However, as this court explained in the Ortiz case, or I guess I'd put it this way, it's instructive to see how the Ortiz court handled this error in the context of that case. They first said, in other words, they did not apply a reasonable, well, in that case it would have been a prejudicial error analysis. They basically said, when the jury convicted on the lesser included offense, they implicitly acquitted on the greater offense. So double jeopardy precludes retrial on the greater offense. With respect to the lesser included offense, that should have never gone to the jury, because the Commonwealth didn't introduce evidence of that crime.
Okay, but in Ortiz it was preserved error.
It was preserved.
Okay, so how do we know, for instance, in this case it wasn't some sort of strategic reason to allow the jury to convict?
Well, actually, Your Honor, I'm sorry, did I interrupt you?
No, go ahead.
Oh, we don't, and it doesn't matter. I mean, basically my argument here is that this type of error, like a sufficiency error, always rises to the level of a substantial risk of a miscarriage of justice. Because if it's acknowledged that there's an error, and yet the case does not get overturned, the conviction is allowed to stay, we basically then have created a situation where we are acknowledging that a defendant has been convicted of a crime that should never have gone to the jury.
Whether it's preserved or not, our review is the same, is what your position.
In this type of error, yes.
Okay.
Like a sufficiency argument. And I would point out
So what's the limit of that? Does that apply to every jury instruction?
No, Your Honor, only this particular type, the lesser included on a sexual offense case, where we have a very distinct one element issue here. We've got the issue here is, was there a sexual assault that created that involved penetration? And when you've got a lesser included offense, and you've got a jury that convicts on a lesser included offense, they have come to a conclusion that you've got all the elements minus penetration. And where you have no reasonable basis on which to draw that distinction, then you then are creating a situation like the Ortiz case instructs. This happened or it didn't happen. There's no evidence that a sexual assault happened without penetration. By the way, that is exactly a good example of the type of case in which there was such evidence is the Russell case. That was cited in the Commonwealth's brief. In the Russell case, the defendant was accused of rape, and there was plenty of evidence of penetration, but there was also a lot of evidence of sexual contact that did not involve penetration. And the court upheld the conviction on the lesser included offense, saying, yes, the Porro case says what it says, and Ortiz, the finding in Ortiz was what it was. But in the Ortiz case, there was no evidence of sexual contact that was short of penetration. And turning to your question earlier, Justice D'Angelo, whether the victim is confused about the definition of virginity or virgin or the definition of rape really doesn't matter, because what she said was, he put his penis inside my vagina, and she said it more than once.
I guess I'm trying to figure out how that does away, and I know Ortiz stands for what you have as a certain principle, but it does away with the general legal principle that a jury can believe everything, something, or nothing.
Well, it doesn't quite do away with that. I mean, I would argue that what Porro says, and there's multiple pieces of the Porro decision, it's not error to give it the instruction, a lesser included instruction, where a jury reasonably could be convinced by a victim's testimony that the defendant sexually assaulted her, but not be convinced of penetration. In other words, there has to be a reasonable basis on which the jury can come to this conclusion: I believe everything up to this point, and then I stop. Only, and again, I don't believe that is eliminating that general principle. The general legal instruction that's given to juries, you can believe everything or nothing or some, like that stands. But when we're dealing with a challenge to a lesser included, a conviction on a lesser included offense, this extra element, you have to have a reasonable basis on which to come to that distinction. I believe everything up to the point where you say, he put his penis in my vagina, that's where I stop believing.
Actually, he said halfway. She said halfway.
Yes.
Couldn't a reasonable jury interpret that to be not penetration?
I don't think so, Your Honor.
What is halfway?
Sorry?
What is halfway? What is putting a penis halfway into a vagina? What does that exactly mean?
Putting a penis inside a vagina.
Halfway.
Well, anyway. Any time a penis is put inside of a vagina, that's a penetration. That's it. Well, halfway, quarter way, all the way, whatever. That's the way I see it. And her initial testimony was, I think, and this was clarified by the prosecutor in her direct testimony, was he put his penis in me, and then the prosecutor kind of backed up and said, well, you said put it in me, what do you mean? And she said he put his penis inside my vagina.
Before that, she testified that he was pulling on her shirt, pulled down her pants. You don't think that would qualify as indecent assault and battery of a child?
Well, no, it absolutely,
okay, so
absolutely does, Your Honor.
Why couldn't, given the attacks on her credibility, the prior inconsistent statements, the first complaint testimony, which seemed to contradict her testimony that there was penetration, why couldn't the jury believe that he pulled down her pants, but there was no penetration?
Well, again, Your Honor, basically, I go back to the Ortiz case. If there is an anal rape, there is sexual contact before penetration, and then there is penetration, and so there is, in other words, in every rape case, there is going to be a sexual offense short of penetration. In theory, that is the nature of the elements, and then when penetration happens, you have a rape.
Yep.
If we ever went in your direction, I'm trying to figure out how your fellow defense counsel in the future would be arguing that means unless the defendant admits to an indecent A and B, you should never get a lesser included. Because this isn't exactly a scenario where, just as Justice Shin just said, the jury could believe everything up to a point.
Correct.
But not afterwards. And if that was the case, that is exactly when you give a lesser included offense.
But
so
there has
how would
to-
we do it in the future if your argument holds the day?
There has to be a reasonable basis for this. In other words, if there is no reasonable basis on which to draw that line, then you don't get that instruction. You can't get that instruction, or I should say, you shouldn't get that instruction. There has to be a reasonable basis. So it's on my fellow attorneys to argue that there's a reasonable basis for this. Here, it's all or nothing. You believe her or you don't believe her. Now, I understand, Your Honor, that it's not just like, and I guess this is another way of coming at it from my point of view. We don't just like snap our fingers and there's a sexual act happening. There is a sequence of events that culminates in penetration. So, but in the Ortiz case, that's what the court faced, and that's how they analyzed it. The jury had the option. There was. The testimony was, he anally raped me. So, and the court said, you could believe that, but if you don't believe that, there's no evidence independent of that of a sexual assault.
All right.
My
Thank
time
you
is
for
up.
your argument.
Thank you, Your Honors.
We're from the Commonwealth.
Good morning. May it please the Court. Jessica Langsam, Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. To the point you just made, Justice Massing, that's why a lesser included with respect to what does halfway mean. And that's why, an instruction on the lesser included offense of indecent assault and battery on a child under 14 was warranted in this case. And as counsel just recounted for the court, I know the court's familiar with the facts, that was the testimony of the victim that she said he stuck it halfway, and that's further detailed in my brief. But also it is, as Justice D'Angelo, you've pointed out, Your Honor, that the victim also testified that after the rape she was still a virgin, and she further testified on redirect examination that when she was 13 years old, she understood rape to mean, quote, when somebody forces you to do something that you don't want to do, like anything sexual touching your body. That's in Volume 4, page 89. So there was evidence in this record that something less than a rape occurred, and for that reason, Ortiz is distinguishable. Because there, the court was quite clear that the only evidence was that the victim said she was anally raped with respect to that count. And when she was asked on cross-examination, essentially whether or not something less occurred, she said no. And further in contrast to Ortiz in this case, the victim never denied that the defendant did not touch her indecently. And as I've just reviewed for the court, there was evidence that the defendant did touch her indecently. This case is more similar to the two cases that I've cited and included, their unpublished orders of this court, DeBarros and Elibert, which both distinguish Ortiz on the ground that, as in this case, the evidence left room for the finding that the defendant did not penetrate the victim, but touched her vaginal area, and the victim never renounced any attempt of the defendant to touch her indecently.
Is Ortiz still good law?
Yes, Your Honor. Ortiz is still good law, and in fact, following Ortiz, and my brother just cited Commonwealth versus Porro. Ortiz was a 1999 case, and Commonwealth versus Porro, which cites Ortiz in Commonwealth versus, so yes, it is. Yes, it is. But I think it stands on its own for this particular set of facts. And here, where you do have evidence and where the court has further clarified, and I believe it was, I was just trying to check whether in Porro the court explained that.
Yeah, they do. There's a footnote that says you can still give the lesser included offense even though the element that distinguishes the two was not specifically disputed or put an issue at trial.
Yes.
Which, I mean, they don't explicitly overrule Porro, but Ortiz, but they seem to pretty much implicitly do it there.
Yes, Your Honor.
But you say they don't. And the difference, and you'd say it better to distinguish it than to say it's not good law.
Let me see, if I might add also with respect to Your Honor's questions, if the theory of the defense, or with respect to your question, Justice Shin, the theory of the defense here was that the victim was not credible because she made changing stories, and that's what defense counsel crystallized in his closing argument. And so defense counsel wanted this lesser included instruction. There was evidence for it. When the verdict slips were presented, he was fine, he was content with them. When the jury came back with that special question as to, we want to convict the defendant Hillen Orana of this lesser included offense, defense counsel was fine with that.
I don't recall reading in the transcript, but did the judge sua sponte in the charge conference just include indecent A and B and nobody objected, or was it requested to by the Commonwealth or the defendant?
The Commonwealth had submitted draft instructions that included that lesser included instruction at the very beginning of the case, but then at the charge conference, which I believe was on the second or third day of testimony, it was further crystallized, and what defense counsel were concerned about was getting a prior and consistent statement instruction and then a statement of defendant not testifying. So this was, it wasn't something that counsel wanted. And there were perhaps the evidence could have come out a little bit more smoothly. It was a little confusing given the time that had passed, and also given that there were two co-defendants, they were being charged with separate crimes, and there were two attorneys who were cross-examining them.
What do we do with the lack of objection, though? I mean, isn't your opponent correct that this is a question of law, like the way we treat sufficiency challenges?
Well, Your Honor, it's where there's a lack of objection, the standard is whether or not it gave rise to a substantial risk of miscarriage of justice. And those factors are set out in ALPHUS, which I cite in my brief for the standard of review. Court looks at strength of the case, nature of the error, if the error was enough to affect the verdict, and if the court can infer if the failure to object was tactical. In this particular case, as my brother has related to the court, and this is set out in Russell, when a claim specific to a jury instruction on a lesser included is presented, if the court didn't give it, then if the trial court didn't give it, then this court looks at whether or not there was a factual scenario justifying the lesser included instruction, and if there was evidence of a dispute at trial about the distinguishing element, which is what Justice Massing just said. If the judge did give it, then the court looks at the propriety as both my brother and I have expressed here, and that is that it's not error to give it where the jury could be convinced by the victim's testimony that that the defendant sexually assaulted the victim, but not be convinced beyond a reasonable doubt that penetration occurred.
So our standard of review is the same, right? Regardless whether it's preserved error or unpreserved error? Would you agree with that? That's what your opponent argues.
No, the standard of review is not the same, Your Honor.
How is it not the same?
Well, for lack of an objection, the standard of review is a substantial risk.
Right.
And it's a substantial risk, and the court goes through the factors
But in
that I've just
application, how is it different? Let's say we can't tell whether defense counsel made a tactical decision or not, but that the decision would have been wrong, just flat out wrong as a matter of law, because there's just no evidence to support the lesser included. Would that matter?
If there was no tactical reason?
If we can't, maybe let's say counsel did make a erroneous tactical decision not to object, but it's clear as a matter of law that the evidence doesn't support the lesser included. Does that mean there's no substantial risk because counsel made a tactical decision?
Well, if there's no basis for the tactical decision of counsel, then that would be a substantial risk of miscarriage of justice.
Right, because that'd be ineffective assistance, right?
Correct,
So
Your
it just
Honor.
seems like in application, it doesn't matter whether it's preserved or unpreserved.
Which often, and that's a difficult line to follow, I think, in application.
Do you have an argument that there's a tactical basis for the lack of objection here?
The tactical basis for the lack of objection?
Is there a tactical basis for wanting a lesser included?
Certainly, Your Honor, because that was the defense. The tactical basis for wanting the lesser included instruction is that, and in reading through Defendant Thompson's closing argument, he says, the victim told all kinds of different stories, and that's why she wasn't credible. Her story changes. That's not believable. She said this to Detective Cox. She said this at the Marlboro police station. She said this at the Sane interview.
It sounds like that's more of an argument for an absolute acquittal, not for a conviction of indecent A and B instead of rape.
Well, actually, Your Honor, that might be so. What defense counsel also recognized, though, is, is counsel said, and this is at volume 4, beginning at page 130, counsel also said at the end of his closing argument, after she's got 3 different versions about what happened, he said, a reading, and depending on how many English majors we have in the crowd, the victim said that he went to rape her. A reading of that would show that it was more of an attempt than of anything that happened. So I think counsel was arguing possibly both, that it was not rape and or that it was something less than rape or that it was not rape at all. And if the court has no further questions, then I would rest on my brief.
I guess not. Okay,
Your
well,
Honor.
the case is submitted. Thank you both. Really interesting case. Okay, so the next case is that we have two paired cases today, but we'll take them one at a time. And so the Hunt case is first up.
May I
Okay.
get some water just really quick?
Yeah, let me I haven't actually formally put the case on the record yet. So the case number 2 today is 22P609, Commonwealth versus Timmy E. Hunt. Put it somewhere that if you spill it, it won't get all over your papers.
Good morning, Your Honors. Hayne Barnwell on behalf of Timmy Hunt. The Commonwealth did not rebut all inferences and all evidence supporting a reasonable inference of racial profiling in this case. These 2 Boston police officers focused a grossly disproportionate number of their patrols in predominantly black neighborhoods. The target of this neighborhood at Mount Pleasant and Dudley comprised 90% black residents, according to Officer Dunn's testimony, and Dunn's testimony both affirms and makes sense of Dr. Fowler's robust statistical conclusions. The reason why the officers are pulling over or encountering mostly black people in their district, which is only 30% black, is because they steer their patrols mostly away from largely white neighborhoods like Mission Hill. The racial targeting...
Okay, that confused you. So you said, you just stated out front what sort of confuses me about the statistical analysis. They're policing in a 90% black neighborhood, but yet the statistics are based on what would happen in a 30% black neighborhood.
Oh, no, so 30% is the entire district.
Entire district, which is
B2. So B2 comprises Roxbury and portions of Dorchester. And so what Don testified to are there are areas like Mission Hill, which have larger white population, and then also Mass and Cass, at least part of Mass and Cass is within his district, that also has more white people. And he admitted that's not mostly where they go. They tend to go, they frequently patrol Mount Pleasant and Dudley in particular, but he said 95% of the people
I
either
didn't see
pull
any
over-
testimony that he didn't go to Mass and Cass, just Mission Hill.
That's right. He explicitly said we avoid.
And Mission Hill, I'm assuming, is made up largely of students.
I'm sorry, I can't.
Mission Hill, I'm assuming, is made up largely of students.
I believe his testimony about students is more Mass and Cass. But that's also, that's uncomfortable to talk about because that's kind of racially coded as well. We have a district that's only 30% black, but he's basically saying, well, they're not really from around here, they're just kind of college students, and so that's kind of racially coded as well.
Counsel, what do we do with the fact that that is all well and good what you just said, and I'm going to accept that that's what the statistics show. But the judge made no factual findings about anything of what you just said. What do we do with that?
I have asked for an alternative, which is a remand, to do that kind of finding. I think one legal point that he was stuck on, which I think now is more clear with this court's decision in Stroman, is, we don't really have a case where, you're racially targeting. I think what he frankly missed is that he actually already had Long, and if you look at page 730 of Long, they favorably note this very scenario. It starts at, quote, similarly, I won't read the whole thing, but it basically says, when you have a situation where you're racially targeting a neighborhood, right, and you're stopping everyone who runs a red light, everybody who runs the stop sign. So that might get them around the pretext, right? There's no pretext, okay, I'm going to stop everybody who's running the red light. But when you're focusing on a black neighborhood like they're doing, the quote is, it could be used to support a reasonable inference that the stops unfairly targeted communities of color and were made due to racial bias. So I think he unfortunately just sort of missed that part of Long, which is a long opinion, and sorry, that was lame. But also later, after he made all these findings, we have Stroman. But to your point about the fact finding in particular, he did, and that was what was. I think he frankly just forgot to integrate that within his ultimate legal conclusions, and I think that would have made them different. Up top, when he's doing the factual findings, he does say, if you're going into more black and brown communities, you're going to be picking up more people of color when you're doing these random license plate queries. So he does put that up top, but then he doesn't kind of integrate that back.
Let's just assume there is discriminatory enforcement of black neighborhoods. On this particular night, they were on directed patrol.
Yes.
Are you arguing directed patrol is unconstitutional?
Not alone, but whether it's directed patrol or just one of their discretionary patrols, if they're targeting black neighborhoods disproportionately, yes, that's a problem. And the other fact that's a problem for the Commonwealth is when he ran the license plate, he admitted it had nothing to do with recent firearm activity, gangs, or anything like that. He gave no reason.
So I take your argument to be that because on most nights when they're not on directed patrol, they have, the officers have discretion about which neighborhoods to enforce, and they're disproportionately going to black neighborhoods, that's the basis of the equal protection violation. But if we're focused on the particulars of this stop, right? So on that night, if they were on directed patrol, I'm failing to see what the basis of the equal protection claim is. Unless you're saying directed patrol is unconstitutional, which I didn't see that being argued.
No, not alone, but he's there because of purported recent firearm activity, and I won't go through all the problems with that I put in my brief. That's greatly exaggerated. So even getting them there is problematic.
Unless there's a showing that that was pretextual. Surely a police department could send their officers to places where there has been recent crime, right? If there's no showing that that was a pretext for the fact that this was a black neighborhood.
Well, pretext is a different question, though, than racially discriminatory enforcement. And also, again, in the particulars of this case, again, when Officer Dunn ran that plate, zero reason given as far as recent firearm activity or gang activity. All he said was, we looked at each other, the driver and I looked at each other, I ran the plate, there was no particular reason for me to run the plate, there was no firearm activity that night. Now, that's the reason.
Let me say something about that. There was no reason to run the plate. His practice was to always run plates. So there was a reason, which was that is his practice, to always run plates, whether he's in the area he was in or he was in another area, because he said, unless we get a call for spotter or whatever, I always run the plates. Is that practice discriminatory?
Because he's avoiding the white neighborhoods, yes. because he doesn't have that same practice when he's going to white neighborhoods, because he never goes to white neighborhoods, and the Commonwealth never rebutted it with any evidence, statistical evidence, for example, that, oh, actually, when he's going to the white neighborhoods, he's running that at the same rate.
The evidence that he never goes to white neighborhoods is his own testimony?
He says he never goes, I think he said hardly ever goes to places like Mission Hill, and he described Mission Hill as having a larger white population. He also described Mass and Cass as having a larger white population, and you're right, Justice Shin, he didn't explicitly say, and I avoid that area entirely too, but if you look at the records, particularly the discretionary FIOs, I did basically a percentage there, and I think it's only like 7% of the time, as a discretionary basis, they're going to Mass and Cass, even though, of course, we know Mass and Cass has problems too of crime. And so again, whether this is a top-down thing or a discretionary, or if they have discretion, this is what they're doing. They are, as a practice, avoiding white areas, targeting black areas, and that's the locus of the constitutional violation, because of course, if you're going to run plates every time in a black neighborhood, it all makes sense now. Okay, so it makes sense that 95% of the time, I mean, that shocked me when I first read that testimony, but sure, it makes sense. 95% of the time, you're going to be pulling over or encountering black people when you're just not going to the areas where there are white people.
This may go more to the Commonwealth and whether they met their burden or not, but can't we presume that Boston Police Department is a big police department? There are certain officers that patrol certain areas of a district in a night, and there are certain officers that patrol another district during a certain night. There's no testimony about whether there were other officers who patrolled Mission Hill. So what do we do with that?
Well, because there's no evidence of that, then that means the defendant prevails, because it was on the Commonwealth. At this point, there's a reasonable inference of racial profiling. It is entirely on the Commonwealth to rebut that. So if they want to produce evidence that, for example, asking the officer, okay, so you say you don't go to these areas. I mean, they could have followed up and said, is that because other officers do those areas? But they didn't ask that. So this is the evidence that we have. They had that chance to rebut. They didn't rebut. They had the chance to bring on a statistical expert to challenge these statistics. They didn't do that. And I did mistakenly omit from my brief an important piece of evidence, so I do want to mention that. On Record Appendix pages 249 to 260, I totally missed this at first, so it's my mistake. Dr. Fowler actually integrates random CJIS inquiries into the violations of automobile law, when they're being discretionary with that. So it's certainly not all of the CJIS inquiries, because these are the ones that result in an FIO or an arrest, but I think those are important too. At page 24 of the May 11th transcript, defense counsel states that he did a calculation of these random CJIS inquiries and then went back to the reports. And he says that 25 individuals were targeted with 19 black, so 70% were black. If the court likes, I can independently verify that and try to track that down myself, but that's what the defense counsel is claiming. Again, that's yet another piece of evidence that the Commonwealth didn't rebut. And so, again... I understand that point. That's evidence that regarding random CJIS inquiries? Random CJIS, yes, it's tagged as random CJIS inquiries. And again, it's not going to be everything, but I think the Long's point is important here, that there's no reason to think they're not going to be similarly racially skewed when you're sort of zooming out and looking at every single one, which of course I frankly don't know how defense could do that.
Are you making basically a disparate impact claim? Because you don't have any direct evidence of discrimination, right?
Well, we have the reasonable inference that Judge Krupp found,
right.
And so again, it's the.
But I mean, it's not based on the true motive of the officer. We don't know the true motive of the officer. We just know the result of their practices.
Well, implicit bias is part of that analysis. So implicit bias, as Long says, discriminatory intent is a thorny question. That's why statistics are the best tool to kind of ferret that out. And so again, once those statistics are there, and Judge Krupp relies upon them. There's no reason not to rely on them. They're exactly, she's using the exact same tools as she did in Long. They're robust. She actually improved upon them. She used weighted averages to account for the fact that they may patrol certain parts of the district more than others. And even still, even if you weight that, you've got 50% black instead of 30% black. So they're still grossly disproportionate, even if you take into account the fact that they're going more to black neighborhoods for, whatever their putative reason is.
It seems to me that you're arguing that the Commonwealth's burden is to justify the practices of the department as a whole, or else the evidence is suppressed. But that's not how I read Long. Their burden is to provide a justification for this particular stop, because by your reasoning, wouldn't it be the case, once you've raised this inference of discriminatory practices as a whole, that all evidence would have to be suppressed if the motorist turns out to be black?
Well,
because you're saying they're discriminatorily enforcing patrolling in black neighborhoods, and therefore there's a disparate impact. I mean, it feels more to me like a 1983 claim or something, right? But here they were on this particular night, they were on directed patrol. The judge credited the officer's testimony that when there's nothing else going on, he's running plates all night long. He had no particular reason he didn't see the race of the driver or the passengers, he just ran it. Why isn't that enough justification for this particular stop?
Because he knows that he even testified, more likely than not, I know I'm probably going to be pulling over a black driver.
Right, because he's in a neighborhood where, so again, it goes back to the kind of overarching challenge that you have to the practices of the department, but that's not related to this, it's not that it's not related, but this particular stop.
But he knows, so his testimony on that night, I mean, based on his patrolling, is that he knows he's probably going to pull over a black person, for one, and for two, Long did not limit this to just the particular officer on the particular night. It said specifically after that, because the Commonwealth only gave you a partial quote, after that it says, this is not exhaustive. We're not saying these are the only factors that the court can consider. You can consider anything that's relevant, and of course that's relevant.
It's a suppression remedy, so it has to relate to this stop.
Right, and the Boston Police Department practices of targeting these neighborhoods are certainly pertinent.
But then all the evidence has to be suppressed.
Yes, but
in any case, regardless of the particulars of the stop, based on the discriminatory practices of the department as a whole?
If the Commonwealth wishes to rebut, and they certainly have the opportunity to do so, they can do that, but they didn't in this case.
I mean, what if the statistics are what they are, and the Commonwealth actually can't rebut them? Is that just determinative?
It is. That's what Long says. It is.
Without regard to the particular stop. That's where I'm really
Well, the
puzzled.
stop has to happen. I mean, it's not like...
Right, but...
It's not like I can just go in and say...
It's a global suppression remedy once a defendant shows that the practices of a department as a whole are discriminatory.
Well, I don't know what the Commonwealth has proven in other cases. Perhaps they've proven that, you know what, there's really good reason for targeting these neighborhoods beyond discrimination. I don't know what that is, but it's not in this case.
Would you, I know your red light is beeping. Would you agree that if the Commonwealth had put in evidence that there's officers in Mission Hill that do the exact same thing, they run the license plates all night, that your case is over?
They run the license plates all night, my case is over.
Just, they do exactly what the officer did in this case, but they do it in a white neighborhood.
Not necessarily, because are they there, you know, once in a blue moon? Or are they there, you know, every night? And
Same officers, like I said.
Right.
One group of officers patrols, as your language,
see.
the black neighborhood, and another set of officers patrols the white neighborhoods. The black officers and the white officers do the exact same thing, one in the black neighborhood, one in the white neighborhood. Is your case over?
No, and because the license plate query itself is so widely discretionary. I mean, this isn't like it's not even like running a stop sign or a stoplight or anything like that. And you know when when he's doing this, he's going to be pulling over a black person. So no, it's not over. Thank you.
Thank you. And we know you have other arguments about this particular stop, but
I would rest on my
they're
brief
on your
for
brief.
this. Thank you.
Thank you.
Good morning, Your Honor. Sarah Lewis on behalf of the Commonwealth. With me today is Assistant District Attorney Caitlin Fitzgerald, who handled the motion to suppress in this case. We are asking this court to affirm the motion judge's decision denying Mr. Hunt's motion to suppress. As for the equal protection claims, Mr. Hunt's challenge fails because, although it's the Commonwealth's contention that the motion judge applied the incorrect legal standard to the defendant's initial burden, he correctly concluded that the Commonwealth had rebutted any reasonable inference of selective enforcement raised by the defendant's statistical evidence. And I would like to turn to the motion judge's findings with respect to the Commonwealth's rebuttal. The motion judge carefully assessed the officer's credibility in this case and correctly concluded that the Commonwealth had met its burden to rebut any reasonable inference of selective enforcement that was raised for 4 specific reasons. First, there was testimony that the motion judge credited that the officers ran the license plate of a vehicle stopped across the intersection from them without seeing the race or even the number of occupants. Second, Officer Dunn testified, and the motion judge again credited that he pretty much ran every license plate he saw, no matter where he was, and he did so without knowing, again, the race of the occupants.
Isn't that selective enforcement if he's only doing that in black neighborhoods?
Well,
If he's only patrolling black neighborhoods?
I would like to point to the record, Volume 2 of the motion to suppress transcript, pages 8 and 16. Officer Dunn testified that his patrol is pretty even during his time in B2, but he thinks, and he did, he said, I think I spend less amount of time in Mission Hill. He did testify that there's a larger white population on Mass and Cass and in Mission Hill of people that tend not to be from the city. But he did say he tends to patrol pretty evenly, but on this night, he was in this area on a directed patrol, directed by his captain. There was clear testimony that the captain each week reviews the incidents of crime where people are most being victimized. And in this case, there was a high incidence of firearm and gang activity in this area, and the officers were there for that reason.
Let's assume as a factual matter,
Yep.
and I'm not saying the record supports this, but let's assume as a factual matter that these officers disproportionately patrol black neighborhoods. Why wouldn't that support a claim of selective enforcement? Even if they're running plates all the time, if they're only going to neighborhoods that are predominantly black, why isn't that selective enforcement?
Well, I think the question is this case, and I think the case law in Long and its progeny, Stroman, Van Rader, each case makes clear that the question is a discriminatory intent and not effect. It's the true motivation of the officers which is relevant, subjective inquiry. And each case makes that clear, and I think that in this case shows that the motion judge credited the officer's testimony that the officers...
The Boston Police Department intent is to discriminatory patrol certain areas and stop certain individuals. Not this officer, but the Boston Police.
Then as Justice Shin raised that might be a different claim, whether it's civil or criminal, but it's not, that's not the record in this case. The record isn't that there was...
I don't know what the record is because you didn't put in any evidence of what happens in white neighborhoods.
And Long makes clear, and also this court's opinion in Stroman, that the Commonwealth is not required to rebut every fact when they're rebutting the reasonable inference of selective enforcement. And I would like to point out that it is the defendant's initial burden to raise a claim of selective enforcement, as this court is aware, and they did so here through statistics. They didn't do so by suggesting that BP...
What difference does that make? Under the Long analysis and its progeny, the defendant makes a claim, and then once the judge finds that claim is met, the burden shifts to the Commonwealth. There was no objection at the trial court level, I don't think, that the defense didn't meet that burden. So that's waived, isn't it?
There was we did not agree that the defendant had met.
Or is there an objection in the record that the trial judge shouldn't have shifted the burden to you?
In the first volume of the motion transcript, there was, excuse me, there was argument on several pages. Ultimately, on page 54 of the first volume of transcript, February 8th, 2021, the court did find that having read the statistician's report, the reasonable inference was raised, but the prosecutor indeed made an argument that the reasonable inference, that the defendant had not met his initial burden, or at least that's our reading of the record. There was also a Commonwealth filed in opposition to the defendant's motion to suppress, and a supplemental opposition as well. So, and I do think, with all due respect, it is relevant because the defendant is tasked with raising a reasonable inference, and the Commonwealth is then tasked, once that's raised, with rebutting each inference raised. And so with only using a statistician's report and not putting in, let's say, raising a claim about the overall discriminatory practices of the Boston Police Department, then the Commonwealth is not on notice to rebut that inference. And I would read from Stroman, the court says, ultimately, the judge holding the evidentiary hearing must, as the judge did here, carefully assess the officer or officer's credibility and determine, under the totality of the circumstances, and in light of the factors that created the reasonable inference of discrimination requiring an evidentiary hearing in the first place, whether the stop was truly made without knowledge or consideration of race. And I think the motion judge did exactly that here. He considered the credible testimony, found that the testimony was credible by the officers, but going back to the point I was making, the inference of racial profiling as a matter of fact by the Boston Police Department wasn't part of the defendant's initial showing in their motion to suppress. It is a claim that's being made, and I think we need to look at this record about how the Commonwealth rebutted the reasonable inference. And again, the Commonwealth need not rebut every factor that the defendant raises. And here the motion judge made clear they did not see, or excuse me, the officers testified and the motion judge credited that they did not see the race of the drivers prior to running a CJIS query. And then further found that the officers run license plates without regard to race, without regard to even where they are, the particular location, without regard to the directed patrol recent firearm activity in this place, in this particular case. And that testimony was clearly credited by the motion judge, and this court is bound by those credibility findings, those careful credibility findings. And I also think it's important that the stop here was for a suspended license. It wasn't a nominal traffic violation. The registered owner was driving with a suspended license, and that's an additional factor. And lastly, the Commonwealth did cross-examine the statistician and expose shortcomings and deficiencies in the statistician's report. The motion judge looked past that and turned to the race-neutral reason for the stop, but it is still relevant and on the record.
Can I ask you about your argument about that, based on Laura, that we should be looking at the statistics with respect to license queries, the use of license queries? Is your argument there that the statistics don't bear out that license queries were used discriminatorily, or that there's no evidence of how license queries are used? You understand my question? Yeah.
Yes.
Okay.
I think my argument would even precede that, but to answer that specific question, the question in an equal protection claim is about similarly situated people or circumstances, and the statistics here were focused on allegedly discretionary stops, FIOs, not motor vehicle-based FIOs alone, but FIOs and incident reports. The statistics did not simply focus on CJIS queries and these officers' practice of running CJIS queries in a particular area in a supposedly or allegedly discriminatory way. And so that would be my argument with respect to the statistics and failure to raise a burden regarding similarly situated people. But
Okay.
But
and-
before-
And Attorney Barnwell argued that there actually was evidence of the use of CJIS queries.
And I need to look back on the record to that specific argument. Even if there was a subset, and yes, some of the reports did, a CJIS query did precipitate an FIO or a incident report with respect to what came down to 55 discretionary reports. But that was a subset in and of itself, and the statistics and the analysis all focused on 55 supposedly discretionary stops out of 1,645 FIOs and incident reports. And it wasn't particularly focused. The statistics, the net analysis wasn't solely focused on CJIS queries and license plate queries in and of themselves. And so if we're looking at an equal protection claim and similarly situated, whether similarly situated people were treated differently, then I think the statistics did not make that showing. But even before we get there, the question that the Commonwealth is raising is the burden at the stage of a CJIS query. If the defendant's claim is premised on the running of the license plate, that's not a constitutionally significant event, not a search and seizure, what's the burden that applies to that, not just the stop itself? Where particularly suppression is the issue, and there's the Commonwealth's.
I'm going to ask you about that, and it may go more to the companion case, but I'll ask it for you, which is, there's certainly case law that talks about police officers can run licenses and it's presumed that the owner is the driver. But the officer testified that in 32 out of 37 cases, the owner was not the driver. So is that a reasonable suspicion anymore with those kinds of, with that testimony?
Absolutely. The 32 out of 37, that testimony was based on a small subset of field interrogation observation reports and incident reports from Dr. Fowler's analysis. The defense counsel pulled out those reports and identified that in 32 out of 37, and only, let me step back. The 37 reports, let's take the total at issue, were reports in which the race of the driver and the registered owner were identified. And of those 37, 32, the registered owner was not the driver. Officer Dunn testified, if that's what the reports show, I agree to that. But in my experience, my everyday experience of stopping cars for discretionary reasons or not, as opposed to what the reports in the statistician's report are, his experience was that 8 out of 10 times, the registered owner is the driver. And I think his experience is relevant here. The motion judge did not think that those, if we want to call them statistics, the 32 out of 37 had any statistical relevance. They weren't analyzed by a statistician. It was defense counsel's own numbers. And they, again, did not show the officer's own experience. And they also only reflected, again, reports in which the registered owner and the driver's race were identified. There might have been other reports that would have been relevant, but that data wasn't in them.
All right, let's use Officer Dunn's testimony. And I'm not saying this isn't right. That's 80%. 8 out of 10 people are the registered owners. Is that enough for a reasonable suspicion to stop every car when it's just somebody whose the owner is unlicensed or revoked? That's reasonable?
Yes, I believe the case law, I might not be pronouncing it correctly, but Pak says the police may, this is a quote, in the absence of any contrary evidence, reasonably conclude that a vehicle is likely being driven by its registered owner. So the question is contrary evidence. And the alleged statistics that the defendant put forth here were not sufficient contrary evidence, as the motion judge found. And in addition to that, there was no evidence, like in perhaps another case, that the officers saw the race of the occupants or who was in the car, such that it would dispel any reasonable inference that the registered owner was the driver of the car. So yes, I think it is absolutely reasonable in this case.
So even though in this case the officer couldn't see who the owner is, there couldn't be any contrary evidence?
Well,
right? until they stop the car because they can't see in the windows, that presumption carries the day.
I would say the presumption does carry the day, and I think the case law is clear on that. And I would even also quote from Kansas v. Glover, a Supreme Court case. It says, the fact that the registered owner of a vehicle is not always the driver of the vehicle does not negate the reasonableness of an officer's inference that the registered owner is likely driving the car. So I think it is a reasonable inference in this case, but particularly where there is no credible evidence to the contrary.
Well, you'll get another 15 minutes in 15 minutes.
For the questions, I'll rest on my brief. Thank you.
And Attorney Schneiderman, you're already here? So let me call the case before you start. The next case is 22P 1163, which is Commonwealth versus Duly. And Mr. Duly is the backseat passenger, correct?
Yes, he is, Your Honor. He's sitting indeed on the rear seat passenger side. That's at transcript 93. May it please the Court, I am Joseph Schneiderman. I represent Dquan Duly. I'd like to start by answering some questions that I think went unanswered in the Hunt case. First, Justice D'Angelo, you had asked about what the Commonwealth did relative to the threshold inference. At transcript 53 to 55, the Commonwealth explicitly says, Your Honor, we are content to rely on you and your assessment of these statistics, and we do not plan to present a statistician of our own. I think that's important and that is compelling because in other realms, the law recognizes that when you don't meet an expert's testimony head on with another expert, you run a risk. Here, the Commonwealth ran a risk by choosing not to do that, choosing not to pursue a Daubert-Lanigan hearing to challenge Dr. Fowler's credentials. The Commonwealth relied on the officers anecdotally. That actually goes to my next point, which is something Your Honor and Justice Shin had asked about, which is what's going on here with the officers. The record reflects that Officer Dunn engages in anti-crime activity. At transcript 9 and 16, he says, my duty is in the K car. The K car is an anti-crime car, so it's up to him to proactively flesh out and seek out crime. So, and though it's relevant because the Supreme Judicial Court in Long has directed us to look at, in the totality of the circumstances, the officers' duties and their patterns.
But on this night, he was not. He was on directed patrol. So are you arguing directed patrol is unconstitutional?
I'm not arguing that it's unconstitutional on its face, Your Honor. What I'm arguing is here, the fact of a directed patrol does not rise to overcome an inference of profiling in light of his duties, and also I would suggest in light of how evidence that this was a high crime area, as the Supreme Judicial Court has refined in Evelyn, was scant. The most recent incident of a shooting was weeks before. I've looked at the statistical reports, and I've looked at the police reports, which were separately filed as Exhibit 2. There isn't really evidence that there are shootings going on in and around Mount Pleasant.
But counsel, that goes not to this officer's intent. Mm-hmm. That might go to the Boston Police Department intent. He is sent to a certain area. We presume an officer is sent to an order. He follows his orders. So what do we do with that? Are you challenging the entire Boston Police Department? Just as Shin said, directed patrols. Are you challenging the Boston Police practice?
We're challenging the practices in context and as applied here. I think that's the key distinction, which is it is the implementation of the practice here. Yes, an officer has to obey their captain's directives. Police departments couldn't work without the chain of command. But here, the problem is that the officers are choosing and indeed are being compelled to go to the predominantly black sections of B2 like Roxbury, as opposed to Mission Hill. And I think in that analysis, all of that actually ultimately more favors us because this officer has experience engaging in anti-crime activities and indeed does not proceed to Mission Hill or Mass and Cass. So I think those factors should actually inure to our favor.
I just want to understand that anti-crime argument you're making. One of the factors that Long tells us to look at is the overall practices of the officer, right? And that's what this is relevant to. Mm-hmm. This night he's not in the K car, right? It's not.
That's correct.
Okay. But you're saying we should, in trying to determine the officer's overall practices, we should look at the fact that he's usually doing anti-crime activity. And how does that make him racist?
Your Honor, I think because it's a totality of the circumstances inquiry, it's objective. The court has to look at everything that was adduced. That was actually something I wanted to address here, which is we don't run into a Garner or a Jones-Pinnell problem of more or different findings for the first time on appeal. Here we have the record. These facts were not discredited by Judge Krupp. Judge Krupp didn't come out in his findings and say, oh, I discredit X and so. He essentially credited all of the testimony. And I think here, where the officer acknowledges that their expertise and realm is anti-crime, that has to inure in the defendant's favor, particularly also in light of the established traffic policies that were introduced here. The traffic policies say that operating after suspension is not a priority offense. The Commonwealth would make operating after suspension into some sort of a Moloch, that it devours everyone. Operating after suspension can occur for any number of reasons. It does not necessarily.
Now, let me ask you about that.
Sure.
So, as I asked the prosecutor, if a police department, that is their practice, to run the record of every license plate between the hours of 11 p.m. and 7 a.m., there's nothing discriminatory about that practice. Would you agree?
Not in and of itself, Your Honor.
So why is the practice of this officer doing that when he happens to be directed to an all-black neighborhood? He's doing the practice of the Boston Police. How does that become discriminatory?
It becomes discriminatory, Your Honor, in light of the evidence that was adduced of who that practice ensnares and how. This actually goes to something Justice Shin had asked about. Suppression here is the remedy because courts cannot endorse violations of constitutional rights of the highest order. Here, suppression is a proper remedy because to hold otherwise would be to put the courts in the business of endorsing racially biased practices. So an officer may run plates, and that is actually an investigatory query which Van Rader fits because Van Rader said we consider investigatory queries to be subject to judicial scrutiny, unlike decisions to prosecute. So it's the officer's decision of how they are carrying out their enforcement duties in the neighborhood that is problematic, and whereas here, the prosecution did not rebut that head-on with a statistician and opted to.
It sounds to me like you're saying the long analysis is entirely divorced from the circumstances of the particular stop in question. Is that what you're arguing? And if that's what you're arguing, I don't understand that because I thought the whole purpose of long was to get at the true motivation behind this stop. Not the practices as a whole, which maybe supports some other claim, like a 1983 claim or something. Mm-hmm. But doesn't the suppression remedy have to focus on the particular stop?
Yes, it does, Your Honor. I apologize if that was not clear. What I'm suggesting is that the practices that lead to the stop, which here it's a historical look back, the historical look back that was adduced here demonstrates that this stop is This stop is the tip of an iceberg. The iceberg here is the systemic, racially biased stopping of individuals in a neighborhood that is 30 to 50% black. And indeed, Dr. Fowler demonstrated that the odds of stopping 78% of individuals who were black in a neighborhood with that demographics are 1 in 100,000. I think those odds have to very much move in our favor, and the Commonwealth has to do something to rebut it. Speaking hypothetically, the Commonwealth perhaps could have rebutted it if this was for drunk driving, if this was speeding at 100 miles an hour, as Van Rader pointed out. The Commonwealth didn't do that. If anything, the Commonwealth's anecdotal evidence actually bolsters the statistical evidence that was adduced here. So I think in the end, even though the focus is on the stop is the tip of the iceberg. And the iceberg here is the history of what these officers doing, what their activities are, and how in the totality of those circumstances, a stop is or may be racially biased.
How do we agree with you and not write a decision that says policing in a black neighborhood is unconstitutional?
Your Honor, you would agree with me by saying that policing, if undertaken in a black neighborhood, must be done on even terms. Officers must be able to actually substantiate something beyond that fact. So it would not be that policing could not occur in black neighborhoods. It would be that the officers cannot, in essence, engage in rousting.
If we had evidence that in Mission Hill, Boston police officers do not run the license plates of every driver from 11 p.m. to 7 a.m., I might be fully on board with you. They say you didn't raise that in your motion and in the preliminary finding that Judge Krupp made. What do? I don't have that evidence to back that up from your argument. So I don't know that. Would you agree, as I asked your, not co-counsel, but fellow counsel, that if we had evidence that the Boston police ran the licenses of every driver in that area, Mission Hill, your case is over because there's no discrimination? Would you agree? I'm sorry I'm not making a point. You have an officer that goes to an all-black neighborhood. He runs the licenses from 11 p.m. to 7 a.m. You have another officer from the same department that's directed to Mission Hill, which is generally an all-white neighborhood. He does exactly the same thing because that's the Boston police practice. Isn't your case over? There's no discrimination. They do this everywhere in the city of Boston. That's what Boston police do.
I'm sorry, Your Honor, I didn't mean to interrupt.
It's okay.
I think that it's necessary but not sufficient to overcome this. The question would be, what do the plate checks in Mission Hill end up turning up? I think that if the plate checks in Mission Hill end up turning up more of that, then I would lose. But I think the question has to be, what is the practice? And then the follow-up question has to be, what does it turn up?
Could you address why your client has standing to raise the equal protection violations of someone else?
I'd be happy to, Your Honor. I think the court, first of all, the Commonwealth's argument, they're making it for the first time on appeal. They didn't make that argument below. They never asserted.
They can do that, right? Because they're urging affirmance.
They could, but there's no evidence on that either way. I think, though, to suggest a parsing here would be at odds with the core premises of Long and of Van Rader and of how courts cannot be endorsing violations of constitutional rights of the highest order. So to suggest that my client, who indeed joined in all of these arguments below, and the Commonwealth never objected to that joinder, would hold him to an unrealistic burden. So I think to say that some sort of, there has to be something more here is not legally sound.
I mean, your argument is just the fact that he was a passenger is enough?
I think it is, given that he is a passenger and his race matches that of the driver.
Why does that matter? Why does that matter?
Right. If he is white, can he raise the claim that you stopped a black driver discriminatorily?
I think that might be a different case, Your Honor, but I think whereas here, all parties engaged in the same inquiry. Indeed, Mr. Duly brought the first motion for discovery here. That should not be an issue, and courts should not be parsing that way. Very briefly, I see I'm running out of time. Your Honor.
When a police department sees a gun next to a driver, and there's the yell of gun, 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 which we all know they do, why doesn't that allow for an exit order of everyone in the car?
Your Honor, I think that concerns for a gun the sighting of a gun does create safety concerns. I agree with Your Honor. Here, though, the safety concerns, though, still have to be specific to a particular occupant, particularly where, as I started with actually my argument, my client was sitting in the rear seat passenger, on the rear seat passenger side, and the gun was found in the driver's the driver's seat. So that's in different areas.
Do you have any case that's, and the Commonwealth's going to get a preview, that says that automatically, that if there's a gun, there's an appropriate exit order?
Your Honor, I cannot give you a cite off the top of my head. I apologize, but my memory is that the citing of a gun justifies a threshold query, but it does not deserve something more, particularly where the Supreme Judicial Court has for the last 25 years held over and over again that exit orders to passengers are more extraordinary than exit orders to drivers, especially given that passengers expect that the business of the traffic stop will shake out between the driver and the officer. Unless Your Honor,
I have one more question.
I'm sorry.
I didn't see anywhere in the testimony where they said they frisked your client. Was there a frisk or not?
The frisk occurred after my client was taken out of the car. I apologize if that was not clear.
I didn't see frisk anywhere. It seemed like they put him on he wouldn't exit, so they took him out and they put him on the sidewalk and they saw the gun while they were putting him on the sidewalk.
That is correct, Your Honor. I addressed that in the reply brief. I apologize for any confusion that may have caused.
I have a question for you, too. You used the term VAL report in your brief. What's a VAL report? I don't think you define it.
Vehicle and automobile law. Again, I
Okay, that's good. Thanks.
apologize if that was not clear. Thank you.
Attorney Lewis, you get 2 bites at the apple.
Good morning again. I guess for the purposes of the record, Sarah Lewis on behalf of the Commonwealth. And again, I will introduce my colleague, Assistant District Attorney Caitlin Fitzgerald, who handled the motion to suppress in this case. And again, we are asking this court to affirm the motion judge's decision denying Mr. Dooley's motion to suppress as well.
Can I ask you Judge D'Angelo's question?
Yes.
If the evidence was that the Boston police ran every plate when they're patrolling Mission Hill, would that be the end of the case? They query when they patrol Mission Hill, they have the practice of querying every license plate.
I think it would, and I actually think the testimony, that's a reasonable inference from the testimony that we have. Officer Dunn testified that he always runs license plates, and he said he does so no matter where he is. Yes,
Wouldn't they? But the follow-up is, wouldn't the evidence have to be also that they do that they are in Mission Hill as often as they are in this neighborhood?
Not necessarily. I actually think that if there was a statistical analysis about it, it would need to be proportionate. So let's say they were in Mission Hill less than, patrolling Mission Hill less than this area of B2. Are they proportionally running license plates at the same rate that they are where they're patrolling, let's say, the Mount Pleasant area more, and are they running more license plates? But again, a proportional analysis. I'm not a statistician, but I think it would, and just to be clear, the question of end the case, again, in the Commonwealth's favor, I believe that here, the testimony as we have it is sufficient, particularly where the motion judge explicitly credited the officers. But yes, if there had been more, a showing raised, the defendant had raised a reasonable inference at that point, and the Commonwealth had put some evidence forth regarding the equilibrium of where the officers patrol, then perhaps, but that's not this case. And on this case, we have enough to rebut the any reasonable inference raised to selective enforcement. I do think it's important to just pinpoint, as your honors have addressed, exactly what's being challenged here. Is it BPD practices? And if that's the case, I think, yes, arguably that would be a civil suit. Or is it the CJIS query, which would occur prior to this constitutionally significant event of the stop? And if it's the CJIS query and suppression is the remedy, then I think a different standard and a different burden applies. Long was specific to traffic stops. Robinson, Van Rader, the question there was.
But I don't know. I mean, in Long, in Long, Laura, we're assuming a totally legitimate traffic stop. They have a reason to do the traffic stop.
Yes, I agree.
So just like, they don't need any reason to do a CJIS query, but in the other cases, they have a perfectly good reason to do a traffic stop, but just you pile the discrimination on top of that.
Right, but from my reading of the defendant's claim, both below and on appeal, is that they're arguing that the decision to query the plate was racially motivated. That was selective enforcement. And if that's the claim, and if suppression is the remedy, and Massachusetts, from my understanding, and New Jersey are the only states where suppression, that allow suppression as the remedy here, and we're moving the point in time to before the actual search and seizure, then I think we get outside the Long and Van Rader framework to back to a general selective prosecution or general selective enforcement framework of LORA, where there is a higher burden, where the defendant does need to show that similarly situated people are treated differently. And that goes to a discussion we had in the prior case and a question that you had, Justice Massing, about the showing here, that there wasn't that showing that similarly situated people, the defendant's statistics did not focus on a broader pattern of CJIS queries involving other motorists. So that would be the framework, I think, if we were looking at just the CJIS query as the focal point of the inquiry. Or third, is it the stop itself? And if the defendant's claim is focusing on selective enforcement with respect to the stop, then the Commonwealth agrees that Long would be the standard. And I do want to just clarify something I said, Justice D'Angelo. You had asked whether we conceded that the reasonable inference had been met. In our final argument, we did say that if Long is the standard, then yes, a reasonable inference was raised here. That was conceded. What I was pointing out was that during the discussion on whether a reasonable inference had been raised, we did challenge that it had been raised. So I just wanted to clarify the record on that.
Can I ask a hypothetical to something that you just said?
Yes.
This is crazy talk, but you have a town where there's an area that is 100% black. You have the other half of the town that is 100% white. If the officer that is directed to patrol the black neighborhood runs the CJIS check of every person in the black neighborhood, but doesn't do it in the white neighborhood, that's what they're trying to say is happening in this case. So why wouldn't Long apply in that situation? That's what they're trying to argue.
Right. I'm saying that the defendant would have an equal protection claim to raise. What the Commonwealth's position is the burden that the defendant has at the initial stage, the showing that needs to be made, should be analyzed under the general selective enforcement framework that was articulated in Laura and prior to that Franklin, as opposed to Long and Van Rader, which create exceptions to that general selective enforcement claim. Framework. They didn't overrule Laura and Franklin, but created an exception. And if the challenge here is to the CJIS query itself, then that doesn't fall within those exceptions. That's the Commonwealth's position, if that answers your question. I would.
So if it.
It's an, go ahead.
No, go ahead.
No, the Commonwealth did file a 16L letter. There is a question before the SJC. It will be argued in May in the case of Commonwealth versus Richard Dilworth about the application of Long outside a constitutionally significant event, outside the search and seizure context, and where the focal point is. And so I raise that to say it is similar to what the Commonwealth is saying here, where the claim being about the CJIS query itself, not just the stop. If we're going to keep moving the needle of the equal protection claims, not that the defendant does not have a claim to raise. I want to be very clear on that. It's just that the burden that the defendant has at that initial stage. But in this case, the motion judge, regardless of whether the defendant met his initial burden, the judge properly concluded that the Commonwealth had rebutted a reasonable inference of selective enforcement for the reasons discussed in the prior case, although I'm happy to delineate them. So Justice Shin, I didn't mean to interrupt you if you have a question on that.
What about, two questions. The 16L letter, what is the context of that Dilworth is trying to move this Laura into now or long into?
So it is it's in a different posture. It's a discovery
Okay.
claim, but that it regards to an investigation on Snapchat. So.
Okay. Right. Yeah. That's
And
kind
there
of
where they pretend to friend.
Yes, and there's an amicus question that relates to the question that I briefed. And so I wanted to bring to the court's attention that was before the SJC.
The second question is this,
Yes.
and I want to put the Stroman lens now on this. Suppose the evidence was not Siege's queries, but the officer Dunn testified like the officer in Stroman. I'm on direct patrol in this area, but I'm on an intensive patrol. I'm going to look for any possible violation I can and pull people over. So if I see a light out, a rear license plate out, say, or a blink, or they don't signal, I'm going to stop them. Is that not the same case?
As Stroman or?
No, as opposed to saying I'm going to run their license plate.
I think what you're getting at is the idea of a general policy, perhaps, or a practice, what I'm going to do in a particular case. I think Stroman answers your question by saying that the relevant inquiry is not a discriminatory effect, is not what happened, but whether there was discriminatory intent. What is the true motivation of the officer? And so I hope I'm answering your question to say that if that was this case, where the officer had that prescribed agenda, let's say, but was not doing it in a discriminatory way, and their true motivation was not to stop people of color, then an equal protection claim doesn't lie. Does that?
No, yeah,
do,
I think you made this argument already too, is that it wasn't Dunn's decision to be there, it was his sergeant's decision to put him there.
There was clear testimony on why Officer Dunn and these officers were in this area, and that was the directed patrol given to them by the captain because of whether it was community complaints or that there was testimony that can inform a directed patrol, but also here the recent high incidence of firearm and gang activity. But just going, and I know Your Honor is aware of Stroman, but the quote is, "The long test looks to the true or subjective motivations of the officer at the time of the stop. Here, giving foremost consideration to the sequence of events prior to the stop, the judge found that the officer in that case, true motivation for the stop was the traffic infraction and not the race of the driver." And we have that.
But there was no evidence there that the bar that the officer was patrolling was frequented by mostly black customers.
Right, and I think that goes back to, again, and I don't mean to be a broken record, but this idea of the effect. So the motion judge did find that these officers were patrolling in predominantly black and brown neighborhoods. That did not mean that what they were doing here, and in this case, was done with a discriminatory intent or true motivation to stop this driver and consequently the passengers based on the color of their skin. And that was what the motion judge credited, and again, the court is bound by. And I'd also just like to point out that I do think it's relevant that they're patrolling in this predominantly black neighborhood, yet only 55 discretionary stops out of this 1,645 were potentially used. If only 55 stops were discretionary out of 1,645 from the total data, I think that's telling in and of itself about what kind of patrol is being done in the area. So again, this goes to the cross-examination that was done by the Assistant District Attorney, and the statistics then being not wholly unrebutted. Yes, we did not have a statistician, but both Stroman and Van Rader say that that's not required. The Commonwealth does not have to put on its own expert statistician to rebut the statistics. Again, the rebuttal can be, what's required is grappling with all reasonable inferences, but not each facet of the defendant's claim needs to be rebutted.
Counsel, can I focus for a second on facts totally related just to Mr. Duly for a
Yes.
second? Which is, do you believe that Brian makes it so as soon as the police officers see a gun that everybody can be pulled out of the car for safety's sake?
I think that it, certainly in this case, Brian controls. I want to say yes. I think it's hard. I don't know the circumstances of every hypothetical, but I think when an officer yells gun and another officer on the passenger side doesn't know if that firearm is still in that driver's hand, let's say, or has been let go and a passenger can reach for it. There was no testimony here of exactly, the testimony was that a gun had been recovered. I think the inferences had been seen. So Officer Dunn, that's all he had. And so yes, I think that when that safety issue in a routine traffic stop as this is at play, then yes, I think the passengers can be ordered out. And I think Brian is instructive, particularly in this case.
But that doesn't extend to pat frisks, right?
The pat, no, I would say the pat frisk here was justified. I mean, you need armed and dangerous as well, and I think they're.
I mean, didn't they pat frisk the other passenger?
Yes, but the pat frisk, I know that, I believe in my, in appellate counsel's reply brief, I don't want to say conceded, but recognized that a firearm was observed on Mr. Duly once he was ordered out of the car and prior to the pat frisk. And so that would justify the pat frisk in this case because you need, so I think, let me just clarify, would Brian extend to, I think the question is whether you would need individualized suspicion for the pat frisk. And I would say you need to, the facts would have to show reasonable suspicion that the passenger, for example, in this case, was armed and dangerous, and we have that here, based on the observation of a firearm in the waistband once he's ordered out of the car. For the passenger issue, I see I'm almost out of time. I would just rest on my brief in raising that issue.
Yeah, well, really, really tough, interesting case, really well argued by all of you, so thank you for giving us a lot to do, and it's submitted. You guys want to do one more, or do you want to break? Okay, we're gonna call one more case, and then we'll take our morning break. So we're gonna hear the fourth case, and then we'll be taking a 15-minute break. And that fourth case is Brown versus Freedberg et al.
Nice to see you. Nice to see you.
If I'll officially call it, which it's 23P771 Dolores M. Brown versus Ryan Freedberg, MD, and St. Vincent Hospital Radiological Associates.
Good morning, Justices. My name is Kerry Choi for the plaintiff appellant Dolores Brown. Modern medicine is why nobody should die from a gallbladder illness if they get to the emergency department of a hospital. Dwayne Brown got to the St. Vincent's ER. He was very ill with an infected gallbladder. He did not get the treatment he needed urgently, and he died. There is no dispute that he would have gotten the treatment he needed if he had showed up earlier in the week, the previous day, any day in the previous week, or the week before that. But on this occasion, the normal on-call radiology service had taken the long weekend off and failed to provide explicit coverage. They had abandoned their watch except for happenstance. A radiologist, Dr. Bird, was credentialed and qualified to do the simple procedure that needed to be done to save Mr. Brown's life. But due to the fact that the defendant radiology group failed to state on the coverage sheet that he was qualified to do interventional radiology procedures, when Mr. Brown's emergency room department physician called to have the procedure done, her name was Dr. Hedges, was told no one was available then or for the next 3 days. Mr. Brown had to be transferred to another hospital's ED, where he was put at the back of the queue, and his workup had to start again.
Counsel, Dr. Bard was in fact at the hospital, correct?
I know that he was working, and he read the X-ray. I believe he was physically at the hospital, but there's no evidence as to actually what office he was at or what suite he was at. I know he was working.
And Dr. Hedges, which is also the same as, that's Van Dyke, right? Same person?
Yes, she subsequently married.
She's another one of the, she works for the same practice?
No.
No, who does she work for?
The radiology group, the defendant, St. Vincent's Radiological Associates, had a contract with the hospital to provide all radiology services, entirely staffed. She worked for the emergency room department.
She's an ER doc at the
Yes.
hospital, she's not a radiologist.
Yes.
Okay,
All right.
thanks.
So she was in charge mid-morning. She became in charge of Mr. Brown. At that point, he had a diagnosis. He had been worked up. They knew what they had to do. We had a surgical consult. A treatment plan was in place. She calls up to put the treatment plan into effect. An interventional radiologist is supposed to be either there or on call, and she was told none is available. And the sheet that is submitted in the appendix shows that there's a column that on the top of the column says IR for interventional radiology. And there's nothing listed. Now, again,
That's the chart that's sort of, I think it's let's see, volume 2, page 4, I think, is that what? Is this what we're talking about?
Yes.
That's
I
volume
think
2,
the
page 4.
dark, I think the dark column on the top of it, I think is IR.
IR call, and there's an X. in it.
Okay, right.
Yeah.
So that says, if you would look at it, it says no interventional radiology, where it turns out that Dr. Bird, I think he is denoted as radiologist number 15 on that chart. You'll see that earlier in the month, on multiple days, he is covering IR. Mm-hmm. And there's no question or dispute that he was credentialed and was capable of providing this service.
Can I ask you a question?
Yes.
So there was a summary judgment, and you actually, it was a partial summary judgment. There was the negligence type claims, the loss of the wrongful death claims. Those were directed. I mean, those were summary judgment against you. But you won the contract claim. So you had a viable contract claim, a third-party beneficiary, and you dismissed that to get a final judgment, right? There was a stipulation of dismissal as to St. Vincent's.
Yes, Your Honor.
So if you lose this appeal, if we agree with the motion judge, but are you going to go back to trial on the contract claim, or is that contract claim gone?
That contract claim is gone. I should point out, it's quite significant, first of all, that there is no malpractice insurance for breach of contract. So the way this particular Superior Court decision has a significant effect on any claim of negligence arising from...
But just focusing on the question, so you say the contract claim is gone, but the stipulation was without prejudice.
The stipulation,
Stipulation dismissing the remaining claims was without prejudice. Why was it without prejudice if you're saying now that you have no intent of going back and litigating the contract claim?
the contract claim was resolved for a nominal amount.
It was resolved.
Yes.
Oh, I see.
And as indicated, there's no coverage. And that has a significant effect not only on this case, but the Superior Court's decision strips coverage from nonfeasance of any hospital providers who are there under contract.
Don't the tort claims depend on the scope of the contract? Because the judge found that there was a disputed issue whether the services you're saying should have been provided, whether those services fell within the scope of the contract. Doesn't that have to be resolved first before you determine whether there's a duty in tort?
No, Your Honor.
Why not?
Because prior to the contract, all right, by about 2 years, the department promulgated a radiology department rule. And the rule says, this is Policy 100, and the rule says to provide the adequate coverage we need at this hospital, this department's rule is we need interventional radiology coverage.
No, but let's say the contract said the group is responsible for providing services on weekends. They should be on call on weekends. Are you saying you'd still have a tort claim against them?
Yes.
Even though the contract says they're only supposed to be on call on weekends?
Oh, if SVR, if the radiology group contract says it's only supposed to be on call on weekends.
Yes.
Yes, in terms of time, yes. If
Right,
there's
so my question is, why doesn't the question of whether there's a duty in tort depend on the scope of the contract in terms of what services they contracted to provide? So if the contract says the group only provides services on weekends, then there would be no duty of any sort, right?
Well,
if the patient comes in on a weekday.
I want to make sure I understand, because the hypothetical, in this case, it was a weekend.
Well, that's just a total hypothetical, but,
All right.
but what I'm asking is, the judge found there was a disputed question about what services were covered by this contract. If in fact these services that you're saying should have been provided were not covered by the contract, would you agree there was no duty in tort?
I'm not sure I followed the question, because as an incident of running a modern radiology department, if there were no contract, except the general agreement that SVRA, the radiology group, is going to staff the radiology department, all right? What we're saying is, as an incident of providing comprehensive radiology care at a hospital with an emergency room, the standard of care is to provide interventional radiology.
They only have a duty within the scope of their contractual obligations.
Well,
right?
in this case, the duties coincided. And
I understand. I'm saying if the judge found there's a disputed question about the scope of their contractual obligations, doesn't that have to be resolved first before you determine whether there's a duty in tort?
in this situation, I'm familiar with the judge's decision, and he says, regardless of the standard of care, there is no duty to provide interventional radiology. And I think we have to separate out duty from standard of care. Duty is, Mr. Brown, as a patient at the hospital in need of radiology services, is not an unforeseeable plaintiff like Mrs. Palsgraf. It is foreseeable he is going to need radiology services. Both the standard of care, as set out in the department rules that predated the contract, it said 24/7 on-call intervention radiology was needed. We have expert support in Dr. Kirkwood that that's the standard of care for an urban hospital. We have the opinion letter of Dr. Hickey in the offer of proof saying that that's the standard of care for an urban hospital. And subsequent, like approximately 13 months after the department rule was promulgated, the contract between the hospital whereby the radiology group, SVRA, agreed to staff the radiology department under the existing department rules also required that there be evening interventional radiologists available. There is no dispute as to what the standard of care was. The other side did not submit any expert report or affidavit disputing that the standard of care, the quantum of care, unnecessary under the circumstances, was to have interventional radiology available. It's undisputed. The judge took the position that regardless of the quantum of care being undisputed, there was no duty. And I believe he misplaced reliance on the case involving snow and ice.
Yeah, before you get there, I just want to ask I think your brief does a good job of setting out why the hospital has a duty to provide an interventional radiologist, and you're saying that the radiology group assumed that duty through the contract, right?
Yes.
Okay. And did they completely then absolve the hospital of any duty? Right, because the hospital is assuming that the hospital had contracted for an on-call IR. Have they done all they need to do to satisfy their duty?
Well, what the hospital did is they said, you are going to take SVRA, the radiology group, you're going to take care of all our radiology needs. The hospital had no radiologists, right, except those employed by SVRA.
But since if they'd contracted for full service radiology, have they satisfied their obligation to any patient who comes in?
Well, I personally believe that if they know, and in this instance they did know that there would be a shortage, I should back up and explain that SVRA wanted the contract to be exclusive to it. Therefore, the hospital's hands, and the hospital agreed, therefore technically the hospital's hands were tied. They could not, even though they knew there was going to be a shortage of interventional radiology, they could not go out and hire an interventional radiologist. So the hospital was trying to delegate out its responsibility to provide that level of care, which it recognized. It said, we want this level of care. So
you dismissed the hospital as the hospital's also been dismissed as a defendant, right?
The hospital was dismissed also as a defendant.
And there's in some of the stipulation of dismissal, it says no payment was made. That stipulation doesn't say no payment was made, right? So can I assume some payment was made?
With respect to the hospital, yes.
Yeah, okay.
Yes, but based upon the actual global situation where they're arguing that we had delegated out our responsibility to this SVRA. And I want to quickly see if I can...
Actually, your time is up. I'm going to ask you in fact, they're a minute over, see if the other judges have any questions. So I think we'll have to leave it at that. I'm familiar with, we've all read the briefs, and I know your argument about about the ice and snow case. So we got that in the brief.
Good morning, we're still there. Megan Pimentel on behalf of St. Vincent Radiological Associates. Just to step back and give a little bit of the procedural history, which I do think is important, there were several claims that were brought against St. Vincent Hospital, against several of the providers in the emergency department, and then subsequent to that, SVRA was added as a defendant, as was UMass. Shortly before trial, SVH reached an agreement with the plaintiffs that resolved their claims for a monetary amount. SVRA also did the same. What remained at that time, following the motion for summary judgment and the decision, were solely the contract claims, and I think that's important for the analysis that we're here to talk about today. That was the only remaining issue as to SVRA shortly before trial.
And just for our procedural purposes, because there is an appellate procedural issue around that. So I saw you nodding. The contract claim is no more.
It
right?
is no more. It is extinguished. It cannot be revived, despite the stipulation saying it's without prejudice because of other documentation that has been agreed to between the parties. That claim is extinguished.
Okay.
And I think for purposes of today, probably partly why that stipulation read the way that it did is so that the plaintiff had the opportunity to appeal the negligence claims, which were dismissed on the motion for summary judgment. So in an abundance of caution, I believe that's why the agreement or the stipulation was written the way that it was.
But your position is that the contract claim is enough, is all there is, and that's right?
Well, what my position is recognizing that there was that outstanding contract claim that survived, any obligations, and really what we're talking about here is a duty of care. So when my brother talked about the difference between separating out duty of care and standard of care, he's absolutely right. A lot of his argumentation that you see, I believe as the justices appropriately pointed out, went to what was required, the standard of care of SVH, of St. Vincent Hospital. What we're talking about is, was there a duty of care that St. Vincent Radiological Associates owed to the patient, Mr. Brown?
So let's say the contract is crystal clear that SVRA is supposed to provide 24/7 care, which encompasses the procedure that the decedent did not get. You're saying their liabilities limited to contractual liability, that they have no duty of care to their patients in the course of assuming their contractual obligations, exercising.
Exactly. There's two separate things. There's the contractual obligations that run, and that's not at issue here, and we're saying for purposes of today, let's assume there was that contractual obligation that they had, which we disputed, but separate and apart from that contractual obligation, in this particular instance, there is no common law duty of care that this SVRA owed to this patient.
How could that be? So let's say that they actually showed up and did the procedure, and they did it completely negligent. But would you agree that a failure to act can also support a negligence claim?
No, and that's what the Anderson case was
So they can
talking
show
about.
up and just stand there and watch the patient.
That's different. So what the scenario was, and I think what the lower court was separating out, and I do think that this is really important. The radiologist didn't show up and perform it negligently, or didn't show up and take a look and say, no, I'm not doing this. There was not even that relationship to begin with. Right? There was no.
Why, if we're assuming that they had a contractual obligation to provide 24/7 care?
That's a contractual obligation, not a common law
but they
duty.
have the contractual obligation. Let's say they just simply don't answer the calls. So the hospital's calling saying, we need someone urgently for this critically ill patient. They just ignore the calls.
That's
not
negligence.
Yeah.
That's different than not fulfilling. So if I take a step back to give a little bit more flavor to what the history was, in 2010, SVRA entered into this contractual relationship with the hospital. Shortly thereafter, it became unworkable. They alerted the hospital, we can't do this. We cannot provide 24/7 interventional radiological care. It's unworkable for us. This had been something that had been an ongoing issue between this corporate entity, SVRA, and the hospital. The hospital was well aware of it. Now, does the hospital have separate obligations, separate and apart from this third-party corporate entity? Yes, they do. But if we take that analysis, any group that has any type of contract is potentially liable for patient care that does not happen. And if we take the case of a maintenance company, contracts with the hospital to clean their operating rooms, to make sure it's free of infection, and they simply don't do that, and therefore the OR is unavailable. Does that patient who died because they didn't get emergent surgery, did they have a claim separate and apart from a contract, with, against that maintenance company? And that's the issue here.
A janitor does not have a duty of care to a patient, but
Neither
surely a
does this third
physician
party.
does.
Just because they're a physician doesn't put them automatically in the position of having a duty of care. That would mean that any physician in that hospital who's potentially available to treat that patient automatically has a duty of care, whether they are aware or not, if we are playing this scenario out.
Right, I'm confused about what the judge found to be a dispute over the scope of the contract. But if we just assume, for purposes of this argument, that the contract provides for 24/7 care, on-call services, including this procedure, I fail to see why they would not have a duty of care to the patient within the scope of the contractual obligation.
I'm saying they do.
Okay.
That's separate and apart, right? And that's the whole point of why we're here today. Because that contract, that claim, that breach of contract claim is already extinguished. We've already dealt with it. So is there a duty separate and apart from the contract? That's the issue.
In other words, the contractual claim doesn't mean there's a duty of care as far as negligence?
That's separate and apart from the contractual claim. Is there a duty that exists in common law that wouldn't have otherwise existed but for this contract?
Counsel, I gotta say, it sounds like a bait and switch to me.
It's not, because we have
I'm going to call it a company, has a contractual obligation, let's put the doctor at the hospital. Let's say that's what the contract says. 24/7, and there has to be at least one radiologist at the hospital. You're saying that that radiologist that's at the hospital because of contract doesn't have any duty of care to patients on a negligence claim?
Not separate, not in common law tort, and that's the issue, Your Honor. It is a claim base, and that's what the Anderson case is talking about, and that's why it's specifically cited. It's not that it's a negligent performance of the contract, it's that there was no performance at all. That is a contractual duty that is created by the contract and so you cannot take contractual claims, and we talk about it in our brief. You can't then repackage them as common law negligence claims.
And does it turn into a potential negligence claim for that doctor that's there contractually at the hospital?
Okay, but again, we have to separate contract from common law negligence, and that's the heart.
Common law negligence, okay.
If they ask him.
Let me ask you the hypothetical following
Absolutely.
up on Justice Shin. There's a contract. It says this company has to have a doctor at the hospital 24/7. Okay? Next step, the doctor's at the hospital. He's there, pursuant to the contract, and he starts examining the patient.
He's created a physician-patient relationship. That is where that duty lies, because he's created that relationship.
Okay, so
But
now
to even-
in this case, back to this case.
Absolutely.
Wasn't there a question of fact whether Dr. Bard was at the hospital?
No, it's not. Because what the facts are is that interventional radiology, that service from SVRA was not available that day. Whether or not Dr. Byrd is credentialed to do it has nothing to do with the analysis, because as per the schedule, interventional radiology was not available. There are different procedures. A radiologist reading films sits there and reads films, whether he's at home or he's at his office. This is a procedure. You're not simply reading films. So the fact that...
Let me take Justice D'Angelo's hypothetical a different way. So the doctor is at the hospital, and the patient comes in, needs a procedure, and he's sleeping, and he won't answer the call because he's been drinking all night. No negligence claim?
No, there is negligence because he is the doctor that is supposed to treat. We don't even get to that analysis because interventional radiology is not available. Dr. Bird is not acting as the interventional radiologist.
We're assuming a world where the contract is clear that the group is supposed to provide interventional radiology.
I don't dispute that.
24/7.
I'm not disputing the
Okay.
contract at all. That's not what's at issue here. And I think
So
this is
how
really
is it different that the group simply doesn't send someone to the hospital versus the doctor at the hospital who's sleeping?
because the breach of that duty is rooted in the contract. That is the distinction here that I'm saying. We have resolved the contract claim. That's where this duty arose from. Is there a common law duty separate and apart from that contractual claim? That is the heart of this. And that is the analysis, is that there is no common law duty of care that SVRA owes to Mr. Brown.
Tell me what the difference is.
SVH would have a duty of care, right?
Tell me
Their
what,
policies,
tell
their
me what the
procedures.
difference is between the doctor who's sleeping in the hospital and won't answer calls versus a group just simply not sending someone, assuming the contract required them to. What's the difference?
But he's there to provide that. There is no provision from SVRA. They've already said that that's a contractual claim. It's not that they're there and refusing to come in and do it. That service is not even available. It's not available per that day. So any duty that SVRA had to that patient to show up.
Why is
To
it
provi-
not,
if I
why
can
is it
just-
not available? I'm not understanding.
There was a contractual dispute between SVH, the hospital, and the radiological.
So you're
group.
saying the contract did not cover this
Yes,
day, this
Yes.
procedure?
yes, because that was the issue. Shortly after this
Is
contract,
is it because of the financial dispute between the hospital and the group that they withdrew coverage? Or is it that the contract, as the judge found, may not cover this particular procedure?
I think there was a dispute about availability of physicians being able to provide interventional radiology. Was it rooted in financial or not? I don't know.
No, it's not the second. It's not what the judge found.
I don't know. What we have before us is that right after this contract was actually executed in 2010, SVRA told SVH, we can't do this. We cannot work this contract the way that it is. SVH, as the hospital, who was the one instituting coverage for interventional radiology, was well aware. They have the duty. We're not, what gets conflated in the briefs is the duties between the hospital and this radiological group. There are different duties of care from the hospital as opposed to this
Was the
third-party
contract
radiological group.
Amended?
They were seeking to amend it. And what we would have argued on the contract claim, and again, the contract claim isn't before this court. What it is was there a duty that was separate and apart from the contract? And what we're arguing is that there is no common law negligence, or there is no common law duty of care that this radiological group owed to Mr. Brown that was separate and apart from the contract that they had entered into.
If Dr. Bird was at the hospital and the ER physician had called Dr. Bird, he's 2 floors up, and said, I have this patient, blah, 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 he needs surgery, would Dr. Bird have a common law negligence duty of care at that point?
It would depend on what the coverage was. He wasn't there as an interventional radiologist, right? And I know it's
No
difficult
idea.
to believe.
He's at the hospital.
But
He's
that would
part
be
of this
like-
group.
But that would be like saying, well, you can do, you're an orthopedic surgeon. I want you to come down and take a look at this patient in the ED. Although he is credentialed to do it, that was what, he wasn't there for that day.
I'm reading
And I don't think it does create.
I'm reading a footnote from, I think it was Judge Reardon's decision. It's page 211 of Record Appendix Number 2. Although the plaintiff contends that Dr. Bird, one of the SVR physicians that approved Brown's radiology reports, was able to perform the procedure at issue and did not, The plaintiff has offered no facts showing that Dr. Bird had a non-contractual obligation to perform the procedure. I don't understand that. He's at
That's the whole
hospital.
point. But that's the whole point about common law duty as opposed to a contractual duty.
And that's what I want you to get through this feeble head of mine. Dr. Bird is qualified to do this procedure.
But because somebody's qualified doesn't mean that they have to go and do it. There is no affirmative obligation for them to then go and do it.
So he's at the hospital and he can read the radiological reports, but even though he can do the surgery, he's not because of the contract.
But it doesn't create an affirmative duty for him to act. That's the whole point. Just because you're a physician at the hospital doesn't mean you have an affirmative duty to go act and take care of a patient. That would be implied to any physician that was in the hospital.
Is the contract that's in the record the contract that was in effect on the day this patient came to the hospital?
Yes, but what we would say is it had been amended through emails and communications.
Prior to the day that this patient came to the
Yes.
hospital?
And that was part, so this is part of our whole, and again, this is why I really want to separate the contract claim. Contract claim is not at issue, or what the contract said, because that claim is extinguished. The contract almost doesn't matter at this point, because is there a common law duty for this radiological group to act absent that? And we contend that there is no common law duty for this radiological group to have acted, or that created a duty of care for them, is what I should say.
Is the evidence of the contract and the disputed emails, is that in the record appendix?
It should be.
Okay.
Yes, that was part of the discovery.
Okay, this is purely academic. Your time is way over, and this is purely academic, but I'm going to ask it anyway. Law school contracts one, first year of law school. What is the contract measurement of damages for breaching of a contract to provide an interventional radiologist?
I'm not sure I'm following you.
What is they have a contract. They have a breach of a third-party beneficiary contract claim.
That was their claim,
Right,
yes.
yeah, that's, I know it's not, that's been resolved, but what is the measure of damages for a third-party beneficiary contract claim? How do you calculate damages?
Again, I'm sorry if I'm completely missing the point. I mean, here, one, we disputed that they even had a contract claim, but because of certain other
Right. But
issues,
suppose, but
we resolved it.
you asked for summary judgment on that and you didn't get that one.
We didn't get it, and we
Right.
got to the point of right before
Right.
trial.
So suppose that it had gone to trial, to a jury, solely on contract duty. How would the jury
found in
Yeah.
favor of them.
and they found a breach of the contract? What are the damages?
Well, the damages, as they were alleging in that particular instance, I wouldn't say it as a general principle, were for the wrongful death of the patient.
Okay.
And that's what they were alleging. And we certainly disputed that there was no third-party beneficiary, that the contract ran between the two, and then any duties to the patient were that of the hospital, not of the radiological group.
All right. Well, unfortunately, we have to leave it at there. We could go on and on.
Thank you for indulging my
Hey, thank you both. Another difficult and fascinating case today. We're going to take a short break. We'll be back in about 15 minutes.
Thank you.
All rise, please.
We're hearing the fifth case. Thank you. We're back on the record for 23P346, Lawrence Lessard and another versus R.C. Havens and Sons and another. Good morning. Yeah, still.
Is it still morning? Yes, just barely. Good morning, Your Honors. For the record, my name is Nina Kellen, and I represent the appellants Larry Lessard and Jen Meshna in this matter. In 2007, my clients entered into a construction contract with a general contractor named R.C. Havens and Sons and its principal, Timothy Havens, to build a high-end new construction home in Marblehead, Massachusetts. Construction of that house took about 2 years. A certificate of occupancy was issued, and my clients moved into the house. After they moved in, damage developed in various parts of the house, which was caused by construction defects in other parts of the house. So there's pages and pages in the briefs about the damage, the construction defects, but just to give you a couple of exemplars, the house had faulty framing, which caused it to shift, which caused cracks in the walls throughout the house. Another example is that a roof deck and siding was incorrectly installed, which allowed water to come through and water damage to all sorts of places in the house. So my clients were unable to resolve this issue with the Havens defendants and filed suit in 2012. That case proceeded to a 2-week jury trial in 2016 with Judge Kottmeyer in the Superior Court presiding. It resulted in a negligence finding in favor of my clients of $270,000 and change. There are other causes of action as well, but they were duplicative. The Havens defendants were insured by the appellee in this case, MSA, which is Main Street America Insurance Company. MSA intervened in the underlying case and took part in the trial. After the trial verdict, MSA went forward with its declaratory judgment action in which it sought a declaration that there was no coverage for the damages awarded to my client under its policy. My clients counterclaimed for declaratory judgment, seeking a declaration that there was coverage, as well as to reach and apply the proceeds of the insurance policy directly, keeping in mind that they've now been living with this issue for, at this point, 15 years. Both parties, MSA and my clients, proceeded to cross motions for summary judgment in the Superior Court, and Judge Buxton ruled in favor of MSA and against my clients on the cross motions for summary judgment. So that's what brings us here today.
So, and for you to win, you've got to really, you have to win you've got to clear the table, right? You've got to show occurrence, property damage, and that none of the exclusions apply, and to prove that exclusion case 6 doesn't apply, you've got to prove that the product's completed operation hazard does apply, right?
Yes, if there's...
Where do we start? What should we focus on?
So I'd like to start with the exclusions. And the reason for that is it is putting the cart before the horse. Typically, when we look at a policy, we start with whether coverage is triggered. In other words, in this case, was there property damage caused by an occurrence? But in this case, I'd like to start with the exclusions because the interpretation of the grant of coverage will be influenced by the very existence of the exclusions. So, as you pointed out...
So the insurance company takes issue with that very proposition, that that an exclusion, just because there is an exclusion doesn't mean that the thing that's being excluded is covered.
The insurance company did say that, but there's two separate legal analyses here. One is, yes, it's absolutely true that an exclusion does not create coverage. But an example of that, let's say you have an auto policy, and the auto policy says the insureds under this policy are the owner of the car and anyone who's using the car with their permission. And then there's an exclusion that says this policy will not cover any intentional batteries with the car, any intentional acts. So the car gets stolen, the guy who steals the car intentionally runs someone over and says, look, I'm covered because I let me back up. The exclusion says any intentional acts by an insured. He says, I'm not an insured, therefore that exclusion doesn't apply to me, therefore I'm covered. But that's an example of an exclusion does not create coverage. That does not mean that we don't look at an insurance policy like any contract as a whole. So when we interpret an insurance policy, we can look at what the whole policy says to make sense of what certain provisions of the policy say. And that's why the exclusions do bear on what is the meaning of occurrence, what is the meaning of property damage. So with respect to the exclusions, MSA has relied on 4 separate exclusions, and I will submit to the court that most of the exclusions, really all of the exclusions, but exclusion K5, exclusion K6, exclusion N, if you follow the language of the exclusions, it's really clear that they don't apply. They apply, it has to do with when did the property damage occur. Exclusion N only applies to certain types of property damage. They don't apply. And I also want to make clear that where we're talking about the business risk exclusions, there is not one single exclusion that says altogether this insurance excludes coverage for property damage to work done by the insured where the property damage is caused by the insured. If that exclusion existed, we wouldn't be here today. There would be no coverage in this case. But all of the exclusions apply to bits and pieces of property damage caused by the insured to the insured's own work. And that's why we look at them one by one. So I would like to focus on exclusion M, which seems like a very broad exclusion, to the point where I would say, just looking at the language of the exclusion itself, if that's all there were, this would be a case, there would be no coverage here for the property damage that we're seeking coverage. But exclusion M has an exception, which is the pivot point of this case. That exception is called the subcontractor exception. And it says, this exclusion does not apply if the damaged work or the work out of which the damage arises was performed on your behalf by a subcontractor. I'd like to give you the history of that exception. It is a relatively new exception, a relatively new addition to standard insurance policies. And as explained by a couple of cases that I've cited, the American Girl doll case is one, and there's a case out of Connecticut called the Capstone case. This exception to the exclusion was a negotiated exception between the contracting industry, the construction industry, and ISO, the Insurance Services Office. ISO is a corporation or nonprofit, I don't know, but they draft standard insurance policies, coverages, which they copyright, and then insurers, if they wish to, buy that language. And they're very common. The policy at issue uses a lot of ISO language, and exclusion N, with its exception, is an ISO.
So at most, what we could do is remand on exclusion M, right? Because there seems to be a dispute whether the work was done by the insured or the subcontractors, right?
So from our point of view, we think that it's really clear from the testimony that we've cited from the underlying trial that there's no dispute that almost all the work was done by subcontractors. But yes,
some of it was done by the insured. So this would have to be remanded to determine what portion of work was done.
Yes, so, and keeping in mind that this is an appeal from a summary judgment decision.
I understand, but this is just one small piece of the case, and I want you to be able to address the first hurdles before you run out of time, which is occurrence and property damage. So on occurrence, I'm having a hard time seeing why Lampro does not control the case, Tree's case.
Yes. So just walking through the definition of occurrence. Occurrence is an accident. Accident is an undefined term in the policy, but is defined by published decisions of the SJC and the Massachusetts appeals case as basically a fortuitous event, an unexpected happening without intention or design, or an unexpected or fortuitous event. The Lampro case, the Tree case, concerned a contractor who was hired to do some landscaping work and went in and, against all the contracts, clear-cut a swath. And that case has been further interpreted by other published decisions to say you cannot accidentally cut down a tree. You cannot accidentally clear cut a field or a forest.
Isn't foreseeability viewed from the point of view of the insured? So isn't it actually less foreseeable if you're going to maliciously cut down trees, which is, I don't think, the facts in Lampro. I think what happened in Lampro is that the subcontractor went beyond the scope of the plans and cut down trees they weren't supposed to. So that seems to me to be equally as foreseeable as a subcontractor doing defective work on parts of a project.
So foreseeability is not necessarily a word which is used in determining insurance coverage. And coverage comes from the point of view of the insured. So in Lampro, the insured did intend to cut down the trees, versus in a construction case such as this, the insured did not intend to put on a roof deck that was going to leak. And that's the difference.
Wait, in Lampro, you said the subcontractor cut down the trees, right?
Intentionally. So,
well, I mean, the same as you put a roof on that, a defective roof on, you're putting intentionally a defective roof on. It's not like they're maliciously cutting down the trees, right?
Well, I don't know whether it's malicious or they somehow made a mistake about what trees they were supposed to cut down. They went to the stand of woods with whatever you cut down trees with these days and intentionally cut down the trees. There's no dispute about that, and then the trees are gone. But in this case, the contractors or the subcontractors did not, they intended to put a roof on. They did not intend to put a roof on that was going to leak.
Well, they intended to put the siding on using nails or whatever, staple, whatever it was that they used that they weren't supposed to use, right?
But the nails and the staples are not an issue here. What's at issue is that because of whatever defective techniques they used, for example, with the siding, water then infiltrates through the siding to something else and causes water damage. And they may have intended to use the nails, they did not intend the consequences of using the nails. Whereas in Lampro, they did intend to cut down the trees, they intended the consequences of cutting down the trees, which was that the trees were cut down.
What is your best case in any field that says that faulty workmanship is not an accident and therefore is covered?
So we would look at what is the definition of accident as interpreted by the SJC in insurance cases. And so the SJC and this court as well has held that an accident, again, is an unexpected happening without intention or design. And then in the DAPI case in the SJC, it went on to say that in Massachusetts state court law, the term accident in insurance contracts is interpreted so broadly that any construction of accident that will limit or defeat coverage should not be entertained, to the extent that in VAPI, the SJC instructed the courts to ignore federal court decisions and to ignore extra-jurisdictional decisions. So if we look at what is an occurrence, it's an accident, and then what's covered under the policy is property damage caused by an insurance. And property damage is defined as physical injury to tangible property. So there's no geography to this. It doesn't say if the physical injury is to a floor that the same contractor installed, that doesn't count. It's just physical injury to tangible property.
You would agree that property damage does not encompass the cost of repairing or replacing defective work, right?
Yes.
Okay. And you would agree it's your burden to show initial coverage, that your claim is covered under the policy, and then the burden shifts to the insurer
Correct.
if the exclusion.
Yes.
Okay, so here's where I'm getting tripped up. The poor workmanship did cause certain other damage, such as the cracks in the walls, but I don't see the damages that were awarded by the jury to your client to be for repair of those damages. For instance, the $100,000 plus, I think that was awarded for the structural defects, was not to repair the cracks in the walls. It was to repair the defective beams.
So the jury was not asked to distinguish between what is the siding itself.
But we have testimony about what the estimate of costs are for, and the testimony was to replace the it'd be $100,000 plus to replace the defective structural elements, which would not be covered.
So the jury was given special questions, which are cited at length in all of the briefs, and none of the special questions asked the jury, what is the cost to repair the incorrectly installed siding itself versus what is the cost to repair the consequences of the siding?
Right, but I mean, I don't see any evidence that there was costs awarded, let's say, for water remediation as opposed to replacing the roof deck. And if it's your burden, so let me take maybe a more clear-cut example. The metal roof, the damages were solely for the cost to remove and replace the roof, right?
Correct.
Okay, so, I mean, I see a potential property damage claim with the mold issue, but you don't dispute that the mold exclusion would exclude those damages. So,
Correct.
I mean, help me, I don't see where there's other damage to other property.
So the metal roof, we agree, the cost to replace the roof itself, not covered. But for example, the water infiltration that comes through the siding into the interior of the building, or to the water infiltration that came through the roof deck, which is different from the metal roof, that goes to the interior of the building and causes damages which is not to the siding and is not to the roof deck. And that's what we're seeking coverage for.
If you haven't pointed us to any testimony from an expert that says the cost to remediate this water damage is X, how do we determine that any of the damages awarded were for water remediation?
Well, then you remand the case to the Superior Court for further findings of fact and potentially another trial if that's necessary. But on this summary judgment, it's premature. This should not have been decided on summary judgment.
Okay.
Thank you. We'll hear from Attorney Melville.
Thank you.
May it please the Court, Michael Melville on behalf of the Appellee Main Street America Assurance Company. As the Court pointed out here, this case is about, well, the first issue is whether or not there is property damage caused by an occurrence. Commercial general liability policies, like the one at issue here, are not builder's risk policies. They're meant to cover...
Are there not what policies?
Like a builder's risk policy, a builder's bonds. For instance, you did not deliver the house that we contracted with you to build. But that's what this underlying case was about. The insured in this case, R.C. Havens, was a general contractor. They had a contract with Mr. LESSARD and the other plaintiff in order to provide them with a brand new house of a certain kind and quality. They failed to deliver on that because of certain defects and faulty workmanship that was within the scope of that. The whole scope of the project, what they failed to deliver, was that new house, and that's what the damages were for. Accordingly, as counsel indicated, these insurance policies are not meant to cover faulty workmanship. That's not property damage. Property damage would be if they damaged something beyond the scope of the project. But here, everything that was awarded was within the scope of that project. So there's no property damage and there's no coverage. Going beyond that, there's also no occurrence.
How do you respond to your opponent's argument that it would require a remand for a trial on which portion of the damages had to do with the replacement of the defective work versus some other damage?
Well, one, I would respond to that I disagree. One, I think there is sufficient testimony to show, well, I don't think there's any dispute that the overall damages are all within the scope in the new construction house. So at the very least, for property damage, the first level, if you're going to follow that property damage is not within the scope of the contract, there's no remand. It's all within the scope of the contract. Her argument was rather that certain individual components damaged other individual components, and that was property damage, which I don't think is appropriate. I think you don't divide it down into the individual component parts. You look at overall the transaction.
Well, the language of K5 and K6 actually does talk about component parts. It says that particular part on which you're working directly, and the K5, K6, that particular part.
Well, that would, if you go to the exclusions, Justice Massing, I believe with the initial property damage of what is property damage. You don't have to get to whether or not you shouldn't use exclusions.
Those exclusions, I understand that argument, but those exclusions speak to, we're excluding the part that you were directly working on. So they're not excluding the part that you weren't directly working on.
Yes, Your Honor, but of course, as a general contractor, they're working on the whole project. That is, if you look at what K5, the K5 exclusion, which we believe applies, or K6, one, they were working on the entire project. If you look at what the sub is working on at the moment, at the time, it's doing that. If it's defectively installing the roof, and if this is, again, going to more of K5 applied rather than property damage, and K5 only applies to things that you are actively doing at the time. If they defectively installed the roof, they're improperly installing the roof at the time they improperly installed the roof, and that's what the damages are for. Again, as Justice Shin indicated, all of the damages awarded and all the testimony in the underlying case, so I don't think it needs to be remanded, because I think the testimony which the jury based its decision on was and what the plaintiffs requested, frankly, was remedying individual component parts. You put them all together, and that's the work of this plaintiff, or this insured.
If work performed by a subcontractor damages a non-defective part of the general contractor's overall work, and that's not property damage.
Well, I would disagree with you.
You're saying it's not property damage.
I'm saying it is not property damage,
right,
correct,
okay.
yes.
So if that's the case, what's the point of exclusion M?
The point of exclusion M might apply in certain other circumstances. Justice Shin, for instance, not a new construction home. If I'm working on, for instance, renovating a pre-existing home, in that case, maybe you're getting into and they damage something that's pre-existing. For instance, if they were doing work on this courtroom.
But it's talking about damage to your work.
Right? Yes, your work, meaning stuff which you did, which happened after.
So why does it matter if you're doing work on renovating a house versus building a new house? It's still your work. It's undefective until a subcontractor does shoddy work and damages it. And exclusion M says that's not excluded as long as the subcontractor did it.
Well, I don't think you have to get to exclusion M because for instance, there's a long history of the courts here where if you don't have property damage caused by occurrence, you don't have a triggering event to create coverage in the first instance, you don't look at whether or not there's a redundant.
So I'm asking you what the point is of exclusion M if you're saying none of this is property damage.
Well, there may be other circumstances, and I don't have it off the top of my head right now.
Let's say you can look at the component parts on a larger project like this. And so, for instance, your opponent says the structural defects resulted in other damages such as cracks in the home. The roof deck resulted in water infiltration. So how do you respond to the argument that there has to be a trial to determine what amount of damages were for, say, replacement of the roof deck versus remediation of the water damage?
Well, one, because there was because we can look at, there was a trial in the underlying case.
Right.
There was testimony of what that was. A jury awarded things, and the plaintiffs requested certain damages in that underlying case. They did not put on any evidence of doing water remediation.
We look at the expert testimony that was presented on the damages?
You can look at that.
Even though there was no special verdict questions?
Well, because there was no evidence of it. Just as if there had been a general question, and for instance, like an auto case, I don't know that we need to, the special questions were presented as to the different component parts, but there was no evidence showing water remediation, which is probably why there was no verdict question on it. There was a verdict question on mold because there was evidence of mold presented. And that's clearly excluded, and there's no dispute about that $18,000.
The cracks?
The cracks, the only testimony in the underlying case, one, their experts did not say there was any actual remediation required for the case. They did not put forth any damages for actually having cracks in the house. What they put forward was evidence. The expert testified $140,000. I think that's the only evidence about what there was, and the jury awarded $117,000, thereabouts. And that was for redoing the actual defective part of the house, which was stabilizing the framing issue, I believe.
Stabilizing the what?
Sorry.
I apologize.
Answer Justice.
Oh, I just didn't hear what you said.
Oh, I believe it was remediating or stabilizing it was repairing the framing. I'm not exact. I'm not a building expert, but I believe that's
Nor am
what
I.
the testimony was.
Okay.
If we find that there isn't an occurrence under the policy, then we don't even need to reach the issues regarding the subcontractors and all that.
Correct. If there's no accident, you never have to get to that point. That's what some of the federal court cases, I believe, dealt with. They didn't even go into that. Judge Buxton did make some findings on the exclusions, but that was more of an alternative ground. You don't have to get to that. If there's no accident, it's faulty damage, which would be consistent with Massachusetts law. And I'd take a moment to speak about what an accident is. An accident is an event that is a fortuitous event. These were probably an unfortunate event rather than an unfortunate event, but it's something that's not expected or intended. All the courts that have addressed similar type definitions in other states besides Massachusetts, and the federal courts and the unpublished appeals court cases, which we don't look at because they're prior to being allowed to, but they all look at an event as not a fortuitous event, because you can expect that you may have to redo work if you put forward shoddy workmanship. That's not an accident. You didn't do your job.
But there's a jurisdiction split on this, at least when the work is done by a subcontractor. And, there is some appeal to me in what the Florida court said, right? So if a subcontractor negligently installs shingles and the shingle falls and hits a passerby, that's considered an occurrence. But if their work damages some part of the insured's overall work, that's not an occurrence? I mean, why should there be any difference?
The Florida court looks more at the formulation of how the policy and what counsel was arguing here about.
Well, the
they added in these
Connecticut
exclusions.
court too. I mean, there's a split.
There's a split on that. The courts that looked at, and I think even I don't know if it was the Florida court or the 10th Circuit, which is also cited by counsel, the courts that define this subcontractor's faulty workmanship as not an accident look at the definition of what it is, and they say it's not unexpected. The other courts say, well, the policy's put together this way, so maybe, by doing this policy and including these exclusions, we can do that, but let's look at it this way. And I think there is actually a case, and I know it's the inverse of this. The Lamp and Sauna case, I think, is a good guide to this case. In Lamp and Sauna, they found there was an occurrence. What did they analyze? They analyzed what did that construction contractor damage? They damaged other elements beyond the scope of their contract. They went beyond that, so therefore there wasn't an occurrence. It was an accident. It was an occurrence. It was something this policy applied to, because they were damaging something beyond the scope of their contract, and that's how they work.
Using Justice Shin's example, which I think she said was from Florida,
yeah.
If a shingle drops and it hits a person, that is not what was generally contracted for, so the policy might cover that.
Correct, Justice D'Angelo, that is correct. That's not something that was contracted for. It's not what the damages are being awarded for here. The damages here are all being awarded to redoing what the insured contracted to do. Therefore, it's not property damage, and more importantly, it's also not an occurrence. It's not an accident. It's
So if you negligently install insulation and it causes mold in the basement, the mold is not an occurrence, or it doesn't fall within the definition of occurrence?
Well, the mold itself is impacting the overall project, the overall contracted for, in this case, because it is
So it's not an occurrence here because the insured contracted to build the whole house, but had it been an existing house, it would be an occurrence.
If it impacted something beyond the scope of what
How does that make sense?
Because they were contracted to, and by the way, if it was take the house down to the shingles and, basically create it, but if I contract to you to build, or you contract with me and I'm saying, all right, I want you to reno the attic of this house, and part of your contract is to install insulation. That insulation is faultily done, and you start creating mold in the basement, which is beyond the scope of what we were contracting for. That is something that is beyond the scope of the contract, you're impacting something beyond this, it's an accident. You didn't, it wasn't you created for a new house construction, they contracted to build a house get a house without mold in it, without water, and they didn't receive that. It was faulty workmanship. And you could expect that if you build a new house, it's not unexpected that, that they may mess up. And there's no fortuity in the fact that they didn't create that.
I've built the basement. I'm the general contractor. I've built the basement. It's beautiful. It's pristine. There's nothing wrong with it. And then subcontract comes in and puts the insulation in shoddily and causes mold to grow all over my brand-new basement. So from the point of the view of the insured, why is it any more or less fortuitous whether the basement was existing or brand new?
Because, Your Honor, first of all, the definition of your work in the policy, just an idea, and it's not used in the definitions here, but just an idea of how these policies work. Your work is work done by you or on your behalf. You're responsible for what your subcontractors do.
So the exclusions might apply, but in terms of whether just something generally is an occurrence, it's a little bit puzzling to me.
Well, that's how we look at these policies, is whether or not it's something, is it a contractual type damage, or is it a something beyond the scope of that, more of a tort type injury. I appreciate that in this case, the claim was negligence. We don't look at the labels. We look at what the underlying awards are being for. We don't use the legal formality in insurance. The same token, you can get a contractual claim could theoretically be covered if it's for property damage caused by an occurrence.
Just lost me. You had me and now you lost me.
I apologize, yeah.
Wait a second. So if somebody hires somebody to redo a kitchen, the contract is to do a kitchen. They build the kitchen, they defectively install a sink. Okay? Follow me. The sink drips and it causes the roof to cave in and the whole basement collapses. However that happens without the house falling down. That's covered, right? The basement part.
The basement part would be covered,
because that
correct.
wasn't part of the
Correct.
contract. It
Correct.
was the kitchen. But if for the sink, the faulty sink, it wouldn't be covered because that was the project.
Exactly, Justice D'Angelo. And I apologize if I'm
Seems backwards to try the way you're talking about.
Sorry, I apologize if I was making it confusing and they are. I apologize,
now I
but
got it. Okay.
that is our argument. Yes, correct. And I may have switched in the middle of my analogy, which was my fault and poor oral argument. So I appreciate. I apologize for that.
I've got one more question for you before you sit down. What's the point of the product's completed operations hazard exception to exclusion K6?
The point of the exception for the product's completed exclusion hazard, Justice Massing, is that it would, under certain circumstances, there may be something which is property damage caused by an occurrence, which may not be this case. If that causes an issue after you've stopped work, the person has been put to years down the line, some damages arise, and it was done by a subcontractor, not by you, that would be something that's covered.
Okay, thank you. All right, thank you both.
Thank you.
Again, excellent job. And give us, this is a tough day today. And, okay, we have one more case. And that would be number 23P462, Mo number 3548 versus Sex Offender Registry Board. And I don't have to remind you that, but no names, we'll just talk about Mo.
May it please the court. Fred Burkholder for Mo. The case is about one simple issue, and that is whether or not the explanation that was provided was sufficient. And as I pointed out in my brief, at least one panel of this court has said what, in my opinion, was insufficient isn't enough. Those of you that have seen me before the court know I like to read things. I'm going to read something to you. This is what the hearing examiner says about the expert's opinion. Although the Static 99 are cited by Dr. Bard addresses some but not all the factors, they do not specifically address the issue of dangerousness, as is the board's collateral inquiry. I therefore give the Static 99 used by Dr. Bard and as testified to at a hearing some weight to the extent that it was correctly applied to the facts, and in so doing only to the extent each may be seen as general indicator of risk. After considering all the factors in this case, I disagree with Dr. Bard's opinion that the petitioner is at a low risk to reoffend. That's not enough. What my brother wrote in his brief, that was enough. This is not. That's my argument. The rest of the case is pretty straightforward. The case I rely upon is DO 40665. It was decided in 2021. And in that case, the court said, we agree with Doe that the board's general reference to the high risk and risk elevating factors and statement that it weighed those factors heavily without specifying which factors or why was not an explicit and objectively adequate explanation for rejecting the uncontroverted opinion. Anticipating my brother's argument, I looked at the discussion as well as the risk of reoffense and the like. This doesn't do it either. This is a mechanical application of the guidelines. It does what it's supposed to do, which is fine. I still think it's mechanical, but that said, it doesn't address Dr. Bard's opinion. What this case points out is the problem that exists with the present regulations, specifically Factor 29, and the amount of weight an individual should be afforded when they have an offense-free time in the community. The science has outgrown what Factor 29 says. As my brother points out, Factor 29 says, specifically, where is it? Let's see. Factor 29 says, risk lowers substantially after 10 years. Dr. Hansen, who everybody recognizes as an expert in this, says, most individuals with a history of sexual offending will no longer present any significant risk of sexual offense after 10 years, and only a small portion will remain at risk after 15 years. Dissidence applies. I might remind this court that but for the 2004 offense, which was not prosecuted, and I know and recognize that the hearing examiner found it to be credible, we have 31 years that passed. No offenses. Even before that. So if you take that, that was 16, that still gives me 16 years of offense-free time in the community. So then the next question that presents itself with regards to the regulations versus the studies is, to what extent does other conduct impact the weight that should be afforded to my argument that the risk is nominal at best because of the offense-free time? My brother points out that Dr. Bard, as well as the studies, say we're not so certain to what extent antisocial activities can in fact impulse it. And I know that's where everybody's going to go because everybody likes to label these guys as criminals, quote unquote, because of their criminal conduct. But we're talking about a sex offense classification, okay? But even
although his antisocial lifestyle includes lots of restraining orders from women in his life.
Absolutely, and it's all due to his homelessness. And if you look at the last incident that occurred with respect to his mother that much was to be made about, his own mother wrote a letter, and in that letter, I'm sure the court saw, she said, he's homeless. He helps homeless people. It's a situation where they find themselves in a situation. He didn't strike me or otherwise. So he didn't kick me was the actual language. So, I mean, the point is what happens with these guys is this. They get classified. This guy was a 1 after the first 2 offenses, a 1. He picks up an alleged conduct, all right? Now, the alleged conduct isn't even clear to what extent what happened with this child, all right? There's an allegation of a lick. That's it, all right? That's not right. That's not good. It's horrendous. That's said. Does that jump you from a 1 to a 3? And then you have all this time that goes by, and you don't do anything else. And although you have some antisocial behavior that exists, there's still 7 years that goes on past that. So maybe it's not for this court to decide whether that's enough or not, but maybe it is for this court to remand the matter back to the hearing examiner to say, explain yourself a little more.
So your point that the brief does a better job than the hearing examiner is well taken. But so if we do remand it, aren't we going to get the brief I mean, what's the point of remanding it if you could do a better job of crafting that decision?
Well, because of the following. What's been occurring of late has been, there was an attempt recently to, and the decision just came out last week or the week before, for these cases to get sent back, and the hearing examiner just to pick up their pen and say, this is what I'm going to change, and resubmit it. And the attorney in that case challenged it and said there were some other issues that went on with regards to an agreement or otherwise, and said, wait a minute, that's not enough. You've got to do more, especially when the amount of time has passed between when this decision was submitted and the present. And hopefully what would happen during that period, during that new hearing would be a serious look at what these new studies are saying. I mean, the whole idea is trying to anticipate what happens out there in the future. And when you have studies that are done, especially by the most respected of all individuals, that says, you know, you better look at this. And my problem is the board has revised regulations that have been sitting in the can for a year or two that nobody releases. By the time they do come out, my brother and I talk frequently because we're here together a lot. Why? Because when they come out, they're going to be outdated again. But what we have here is extremely outdated because there's a big difference between what Dr. Hansen says and what these regulations. The same thing applies with age, although it's not relevant in this case, but the studies now say that at 70, you got no risk. Are you going to ever have no risk? Of course you're not.
Do the revised regulations include revisions to Factor 29?
I have no idea. Nobody's seen them. They haven't even been out for public comment. As I understand it, the process from this point forward is still, would be months to years, you can ask my brother, until they'd be out. But this is, again, the type of case that caused the regulations to be revised back when 15164 and 21564. Those cases came out. Same problem here. This case brings it to a head because if what your fellow jurist said was a decision with regards to what was adequate or inadequate stands, although I know it's not binding, then I've made my case. And it's up for the hearing examiner to maybe take a more serious look and say, as they did in this case, they said at the end of the opinion, on remand, the board may consider whether Doe's offense-free time in the community has continued since the board's decision and on what impact, if any, that factor has on Doe's classification. That's my case.
Is that in your brief?
Yes.
Which was?
Yes.
Is that for?
It is cited in my brief, but since I have it in my hand,
Yeah.
I'll tell you what it says. It says Doe 40665.
Oh, it's 40665.
Right. AC 20 P 911. It was issued November 30th, 2021 by Judges Milkey, Kinder, and Sachs. And it was a Rule 23 decision.
How often can an offender move for reclass?
Every 3 years, so he can't do it yet. To digress, but what happens with these guys, because of the volume of the work that I do and because I really try, and they know I try to get the results for them, they call me. And they tell me, especially this guy, I was a 1. I mean, now I'm a 3. Now I can't even find a place to live. Even assuming that I did what they say I did, look at how long I've been free. Why am I a 3? And you know, the difference between a 3 and a 2 is huge out in the community. It's huge. Because as soon as you say 3, landlords say forget it, employers say forget it, schools say you can't live next door, and the police knock on your neighbor's door no matter where you live and say, you know what he is. I guess at some point, the scarlet letter has to fade. I have nothing further unless there's any questions.
He's a 2.
Again, please?
He's a 2.
Oh, he's a 2. I want him to be a 1. I'm sorry. I misspoke. I get excited sometimes.
Yeah.
Do you read the remand order in 40665 to mean the taking of additional evidence?
Well, I mean, yes, to some degree, or at least more serious consideration of that time. And I think when you say that, I think you have to look and say, all right, well, what does that time mean? I mean, that's what we're all trying to do, is to say, what does that mean? And, I was thinking about this. It's unfortunate, but because these cases are all sealed, we never have the benefit of the actual decision. I'd love to see what the hearing examiner said, because then it would give us an idea whether they were just so, not on the right page, that they were compelled to do this, or whether more was done. I guess what I'm hoping for is that in these cases where they find a reclassification not there, and yet they haven't done what they are required to do, that yes, more than simply a rubber stamp should occur.
On the level 2 now that we've established, I want to hear your argument that why it's so important to, you made a good argument why the difference between a 3 and a 2. Tell me the difference between a 2 and a 1 from your client's point of view.
Well, I mean, it's on the internet versus it's not on the internet, which makes all the difference in the world. I mean, the sad part with the internet is that once it's out there, it's out there. But be that as it may, when
not as much knocking on the doors and letting you live.
Well, no, the knocking on the doors and the like happens when you're a 3, but as a 2, you're still on the internet. And it's as prolific as everybody's on the internet. Even old people like me look on the internet and see what it says. So, I mean, it's never good to be anything, but if you're going to be a classification, be a level 1. At least that way you can have some opportunity to find places to live, and people can't find you as much.
Okay.
No further questions?
No further questions. We'll let Attorney Shinai bring us home.
Good afternoon. If it pleases the court, David Shinai for the board. The board's position on this is that the hearing examiner did do enough on the analysis of Dr. Bard's testimony and evidence.
So can I ask you a question that I actually, it's written here on my notes here, okay? It didn't just occur to me, but my question, I do say, you state at page 26 of your brief that, quote, the hearing examiner found that Dr. Bard's analysis did not adequately consider the full scope and nature of the plaintiff's sex offending and antisocial behavior. And you go on to explain in good detail the holes in Dr. Bard's analysis. But where in the decision does the hearing examiner actually say that Dr. Bard's analysis is not sufficient?
What I did is I looked at the fact that he talked about the fact in his decision that in the end he found additional factors, and I go back to all of the factors that that the hearing examiner reviewed in making the determination, such as repetitive and compulsive behavior, child victim, the fact that he committed his sex offense as a juvenile and then later as an adult committed another sex offense. Those were factors that Dr. Bard didn't consider, but they are specific factors the hearing examiner did consider in making the ultimate risk and danger analysis and classification decision. So I think it's more of a connecting up of the whole hearing examiner's decision and as opposed to in stating specifically that he found additional factors not considered by Dr. Bard. And again, in the first part of his decision, he's explaining all of the factors that he's using. So I think the roadmap is there as to where he differed from Dr. Bard in the decision-making process.
So he says after considering all of the factors in this case, I disagree with Dr. Bard. That's what you're reading that in. That's what we read. That's the language.
Right. I'm reading it to mean that he's saying that there's additional factors that weren't considered by Dr. Bard, that he's considering different factors. Because he says, when I consider all of the factors, I think he's making it exclusive of what Dr. Bard had put forth.
But isn't the statement that Dr. Bard did not specifically address the issue of dangerousness, to the extent that was relied on by the hearing examiner, wasn't that error under, I don't remember any of the numbers, 2, 3, 6, 5, 6?
Yeah, that really shouldn't have been written in there because I don't think, Dr. Bard was specifically talking about risk. Right. And the hearing examiner should be analyzing Dr. Bard's decision based on risk, on what the risk to reoffend as opined by Dr. Bard. The dangerousness was gratuitous in a sense.
What do we do with that when the discussion is very summary and then you have this error in it?
Well, I guess you can consider it a Scrivener's error.
A Scrivener's error.
I have what's in front of me, and I take what's in front of me to make, the argument that supports the hearing examiner's decision. I think ultimately in this case, this individual, and I really think it comes down to mental instability that he displayed from 2012 all the way to the hearing, and the different events, the fact that he was off of his medication, claimed he didn't need medication anymore, but even his mother and an ex-girlfriend were saying he really needs to be on medication because he's so erratic. And I think it's the instability that kept him at a level 2, because that instability was causing widely different but still dangerous antisocial behaviors. And I think that that's really the pertinent fact in this case, that I don't think a level 1 was warranted under these circumstances. I think it was a fair decision in the end, regardless of the hearing examiner's summary opinion as to Dr. Bard's opinion itself.
So, Mr. Shinai, you've done a very nice job in your brief explaining why a level 2 is appropriate, but these SORB decisions do have this checklist feel to them that we don't see in other types of agency decisions, and I think that's largely a symptom of the way the regulations are written. Be nice if the hearing examiners, once they get to the part of the opinion that says discussion, connects the dots like you did.
Well, I don't get paid enough, though, to be the hearing examiner, so I understand what you're saying.
If they could try to do that.
I will send word back. I would say this, I've been doing this for 20 years, and this hearing examiner has been only for a couple of years, so I think that's also a difference.
So when you started doing this, the SJC was saying, your regulations are out of date. When are you going to revise the regulations, right? And you probably heard that for 5 years or so, and then finally they did revise the regulations. How, in 2016?
2016, right.
So now we're coming on 8 years after that, and is that also a chorus that you're starting here again?
Well, the interesting part is, after the last ones were done in 2016, they did start the process for the next round. The problem we're having is that it's a very onerous process. First of all, you get the regulations together, then you have consultation with CPCS, then you send it to where it is now, to EOPS. Now, these regulations were sent to EOPS quite a while ago, and for some reason, they haven't been released by EOPS. Once they're released...
There are a bunch of lazy people, but EOPS. I personally know that, so as the former general counsel,
Okay, so the board's done everything it can to get new regulations. It's held up, and then when they come back, we still have to have the public hearings, and before we can even get them enacted. So it's turning out to be a process, I think, that's antiquated for what the board needs to do, which is to try to keep up with research. And that's why Factor 37 is there, so that new research has to be considered by a hearing examiner if presented. I think that's DO 151564. So there is theoretically a safety gap, but we're going to get these regulations in place, and I'm pretty sure that there's been a couple of studies post the regulations we created. So I don't know that there's a really good answer for that, other than I think the process for us to get new regulations is so time-consuming and so slow, it's hard to keep up with the regulations being with the most updated studies at that time.
Yeah. That was a joke, by the way, about EOPS. So just in case anybody from EOPS is watching on the internet there, that was just a bad joke. I apologize.
But, I think that my brief, I've done the best I can to spell all this out, and I'd be more than happy to rest on my brief.
Okay. Thank you both.
Thank you.
We will take the cases submitted, and that will conclude today's hearings. I want to thank the court officer and the clerk over there, and we'll be in recess.
Thank you.
All right.